Yes.
If please, my Lord, I appear on behalf of the state in this matter.
May it please the court, my lord. This may be my first appearance before your lordship. I am Roberto Avila, A-V-I-L-A, from the law firm Metcalf Bierkus Attorneys. My lord, I appear for the 4th and the 24th accused in this matter, standing in on behalf of Mr. Bierkus.
Please, Your Lordship, I appear on behalf of at least 5, 10, 12, 13, and 14, as before.
In this application?
Not in this application.
Or you are just in attendance?
In the main application, yes. In this application, we are just in attendance.
Okay.
That is the question.
Yes.
As the court pleases, my lord, I appear on behalf of accused number 7, 8, 9, 23, 25, 26, 27, and 28 in the main trial. As far as this hearing is concerned, we are just here to observe. As the court pleases.
Yes, for the applicants. The applicants.
My lord, Ricardo, I continue to be in person.
In attendance as well. In attendance as well.
Well, I believe so.
Yes.
Morning, Judge. Here.
Morning, Judge. Shanghala here.
Yes.
Good morning, Judge. Pius Mwatelulo.
Yes. Is anyone outstanding? Yes, we are here to deal with the application by 3 of the accused persons. Mr. Shanghala, Mr. James Hatuikulipi, and Mr. Pius Mwatelulo. Yes, may I call upon the... Are there any preliminary issues?
Yes, Judge. Indeed, there are. The first thing, it's a bit pedantic and beneath the court's good standing, but I must again ask the judge if you could kindly arrange that I be given a chair here for my scoliosis back, the condition where my back is bent. It, after a while, hurts. But in the meantime, I can proceed since I'll probably be on my feet. The second issue, Judge, is if you do not mind, once we've, in the proceedings today, handled the issue of the application before you, are we able to spend some time on the other outstanding administrative issues, which if I get into now will just derail us? Once we've done with the matter at hand, that before you adjourn, that we spend some time, I can indicate those issues. Then or now, it depends really.
Yeah, we'll get to that once we are. You know, the purpose of today is to hear this application. But we'll probably hear you at the end.
Yes, Judge.
Okay. Yes, Mr. Shanghala, you may proceed.
Thank you, Judge. Let me just must apologize because the setup here, as I've lamented before, is not really conducive for the type of trial envisaged. I've just brought a couple of documents which I'll be handing up. And as you can see, Judge, it's quite a mess here. The application before court, Judge, is an application for questions of law to be reserved.
It's an ex parte application.
Yes. It's an ex parte application on the basis that no relief is being sought against anyone. It's relief being sought from the court in terms of Section 319 of the Criminal Procedure Act, 51 of 1977.
You are aware that in terms of Rule 72 of the High Court rules, an ex parte application is made to the motion court.
Excuse me, Judge?
Are you aware that in terms of Rule 72 of the High Court rules, sub-rule 1, an ex parte application is made to the motion court?
Well, I'm also aware, Judge.
Are you aware of that?
I'm aware of the rules.
Aware of the point I have raised?
I'm aware of the point you have raised, and in response thereto, I was about to proceed to indicate to you that I'm also aware that the rules do not cover for every possibility. In fact, the rules have gaps in them. It has been found so by various other courts. So, for instance, this being a criminal proceeding, we only have Rule 114 in the rules of the court that deals with criminal proceedings. And it couldn't have been the case because other applications are brought before a criminal court. Many interlocutories.
Maybe I can assist you there, Mr. Shanghala.
Yes.
Section 319.
From the CPA.
Yes. Subsection 3, is it?
Excuse me, Judge?
Subsection 3. Is it the one which says certain provisions of the CPA will apply? Subsection 3.
sub 4.
Is it sub 4?
It seems that my copy doesn't have a sub 4. It ends with a 3.
I said 3 myself.
Oh, sorry.
The one which makes reference to section 317.
Yes.
What does it say?
The provisions of sections 317, sub 2, sub 3, sub 4, and 5, and 3182 shall apply mutatis mutandis with reference to all the proceedings under this section.
So, what does the first one tell us? 317. The first referred to.
Basically, that these applications are brought before the judge or another judge, and
that is the application for the reservation of a point of law, isn't it?
Yes, the 317 is for special entry of irregularities or illegalities, and then applied now mutatis mutandis to questions of law, that they can be brought. So Section 319 empowers you to bring them. It doesn't dictate the form in which they arrive. It says you're empowered to bring questions of law, But from the case law that I've read, there's no way. In fact, it's not prescriptive, neither of the form nor what you must allege.
Now, let's not come to conclusions. Let's not come to a conclusion. I'm just asking, isn't it the proper approach in this matter dealing with 317 sub-rule 2 to make your application? Is that not the proper approach? Because it says that one, 317 subsection 2, 3, and 4 deals with an application under or in terms of 319. Is that not so?
Yes, it says if the judge is not available, it's not saying...
No, it's not about, but that is the rule in terms of which, or the section in terms of which you bring the application.
And maybe at this time the judge will probably help me understand what is the significance of that particular rule you're addressing me to.
The significance of it, if I may help you, is simply that instead of making this an ex parte application, you would have made an application applying the provisions of section 317, subsection 2, 3, and 4.
Well, my understanding is this, that the empowerment to bring the application and the form in which you bring it are two entirely different things. The rules of the court detail the how, and the statute details the what. You bring a question of law to be reserved, and I assume that the rules say whenever you apply, you shall bring it on a notice of motion, with the exception that matters may also be brought under action proceedings. So my understanding of the rules is at odds with what the judge is expounding, and perhaps I need to refer to rule Yes, Rule 17 of the court's rules, which deals with the case management of the matter, that the court must seek to give effect to the overriding objective referred to in Rule 1 when it exercises any power given to it under these rules or in interpreting any other rule or procedure or practice direction applicable in the court. So the overall objective is to have the questions of law reserved. The how is not necessarily stated either in the rules or in the sections that you've referred me to, 317, 318, 319. It doesn't even say it should be an application. But it being an application allows the other party or anybody interested to have the opportunity to respond. This ex parte application was brought because no relief is sought from anybody, but in any event, everybody was served. Only one party responded. There is no prejudice, and these rules, by the way, shouldn't enslave the court. In fact, the court has said the rules are for the court. It becomes pedantic and justice becomes strewn by the sideway.
Mr. Shanghala.
Yes, Judge.
Your submission is proceeding in terms of Rule 72 is the correct approach. Is that your submission?
My submission is, in terms of my notice of motion, I've applied for condemnation if the rules are not complied with. The court has the power to grant the condemnation. My second submission is that the rule, the section 317 does not dictate the how, neither does 317 or 318, and that those sections are indeed what entitles me to bring the questions of law, but not the how. The how, I use the rules of the court.
Can we deal with one point at a time? I'm just wanting to understand from you. Do you persist that bringing this application in terms of Rule 72 is the right procedure? That is your submission.
In the absence of any other, yes, but my case, Judge, is to be judged on the papers submitted. I stand and fall by those papers. In the first prayer, seeks condemnation. The court is entitled to condone on the basis that the rules are not clear, on the basis that the section does not articulate the how, and on the basis that as it empowers under 319, read together with 317, I was entitled to move in the manner that I did, and that I am before the court properly. In any event, I've referred you to Rule 17, and I want to refer you to Rally for Progress and Democracy, which says that the court shouldn't be hamstrung by the rules. A court that is intent on doing justice will...
The only reason I was raising this, Mr. Shanghala,
Yes, Judge.
is that it is a case that can provide guidance as to future applications of this nature.
Yeah.
So that this court can attempt to outline the correct approach, the correct procedure, whether you go in terms of Rule 72 of the High Court rules or you follow the provisions of Section 317. But I get you. You can proceed.
Towards the end of my submission, I was going to suggest, Judge, that as you suggested in the recusal application, maybe it's worth mentioning to the rule maker that there's that gap as well, because there are other issues that will arise.
Well, depending on whether I agree with you that there's a gap.
Indeed, Judge.
But anyway, the whole point is to say for future guidance, it might be important to know how you bring an application
Yes.
under 319.
I agree with you, Judge, in that respect. Pro tanto, we are in agreement. Judge, before I just get into the thick of it, kindly, I've provided you an indexed file. I hope you have received it.
Yes, I did.
Yes. I'd like to refer you, Judge, in that index file, there's a replying affidavit. That replying affidavit is at page 37 of the index file, but the page I want you to go to specifically is page 48. And on page 48 of the indexed file,
Can I just, since you are making a reference to that file, can you get the file for me? But in the meantime, you can proceed.
but I'll get back to those issues. Let me just start off by saying, Judge, that if we can create a mind map, per se, we are here because of the events that led into the pleas being taken. These questions would not have been necessary had we not proceeded into plea taking. And the only objective is to ensure that if the questions of law are reserved, stated, specifically recorded and transmitted to the High Court, Superior Court, dealt with by the Supreme Court, that this matter would resume in pre-trial conference, because we had not completed pre-trial. And Judge, this is not just me. I will read you what Mr. Marondedze himself had indicated at some point on records. And
can you just be clear on one issue there? You are saying these issues or this application would not have arisen if we had not entered into plea taking.
yes, indeed. Had we not entered into plea taking at the time that we did and in the manner that we did, I'm pretty sure that I would not have raised these issues.
So the reason this application has come about is because we entered into plea taking.
In the manner that we did. And before we leave that point, Judge, I will be addressing that particular issue. because it has been raised by the state in its very paper-light and thin response. If you have the file, Judge, may I direct you to page 48 of the indexed file, at paragraph 48 of that page 48. In that paragraph, there are two sentences. And the second sentence starts, a section 317 special entry can only be stated. It is a mistake. It should be a section 319 entry, not a section 317.
Paragraph what?
Paragraph 48 on page 48. There's the sentence, section 319 relates to questions of law, not questions of fact, and is akin to a section 310 for the lower courts. A section 317 special entry, that reference to a section 317 entry should actually be a section 319. Similarly, 319. That 317 should be a 319. That's the correction I wanted to make.
Would it make sense?
Excuse me, Judge?
With that amendment, would your sentence make sense?
Yes, it would. Because, and I will refer you to the cases. It's actually language. You'll see there that I think it's Tucker. The case is Tucker. It's a
All I'm saying,
case that I'd like to refer you to.
all I'm saying is that sentence is talking about a special entry.
Yes.
So, a section 317 special entry can only be stated by the court if it arises at the trial.
Yes.
By court acting on its own accord. So the whole sentence is concerned with a special entry as distinct from a reservation of a point of law.
What I'm trying to correct is to say that I meant to say a section 319 reservation can only be stated by the court if it arises at the trial, and the emphasis in that sentence is really at the trial, by the court acting of its own accord, or at the instance...
Then you must amend a lot more in that sentence. To just say section 319, a special entry, because it's not a special entry.
No, it would be 319 reservation.
And then the words in quotation would have to be amended as well.
No, the at trial remains. That is exactly the point that I would refer you to the Tucker case. At the trial.
But if we go by section 319,
yes,
does it use the word at the trial? Anyway, you can give me the reference to the Tucker case. Is it?
It says on the trial, on 319, but the section 319 has a history, which I'll also get into, and those cases have then interpreted the language used.
All right. Can I have the Tucker case? The one is...
I'm going to give you everything, Judge. I'm going to give you... I was just making first the amendments, and then I'll get into the issues. I will definitely give you all those issues so that they're in context. I've got a bundle for you. Actually, let me just give you the bundle now. I don't think this will pass through here. Our uniformed friends may have to open a door.
The other point I wish to make, you must assume, and you will be correct,
Yes, Judge.
that I've read your papers.
That is wonderful news.
Yes, that I've read the papers, the idea here, and you have filed your heads of argument.
Yeah.
The idea here is not to go through everything in your papers because I've read them.
Yeah.
The idea is for you to highlight what you think needs to be added or subtracted from from your heads of argument.
As it pleases.
In other words, I would have expected you to say, I stand by my heads of argument.
Yes.
And then I have these additional points to make. Otherwise, we'll spend the whole day here. I've read your papers.
Yeah.
You have filed your submissions.
Yeah.
If you stand by them,
Yes.
you advise the court,
Yes.
and we take it from there.
Just so that I can record that, Judge. First, it pleases me very much that you've read the papers. I must apologize for their prolix nature because I had to clarify certain issues. Secondly, I do stand by those papers. And thirdly, I do intend to highlight particular aspects of those papers, to which extent it may help, Judge, if you can give me a time frame that you will permit me to inundate you with and serenade you with my voice.
I will be very reluctant to be inundated, but you can proceed.
Thank you, Judge.
It must be reasonable time. I don't want to say to you, you do it in 15 minutes.
Yeah. Well,
the whole point is, I say, these are application proceedings. You have filed your main application.
Yes.
You have filed your submissions, which
Yes.
you say you stand by.
Yes.
And you only need to highlight a few things or what you think is necessary for emphasis.
Thank you, Judge.
And then if I have any questions, I will ask you.
In fact, Judge, may I also be given from the time that the state would have, they haven't filed papers really, so they wouldn't be on their feet for long. The papers are 6 pages, 5 paragraphs, 3 pages. So if you can indulge me also there. But let me proceed. Also, Judge, if you go to page 29.
Are you in the middle of your submissions? Because you raised certain preliminary issues, didn't you?
Yes, I'm raising those preliminary issues so that I can get them over and done with. At page 29 of the index file, Judge, are a list of the authorities. And sorry, not page 29, but page 29 of the heads. Of the heads. Judge, at page 29 of the heads, I make reference to cases that are Namibian cases. I just want to correct there that the following cases are not Namibian cases. That's case number 6, case number 8, case number 10, and case number 11. That's now the case of Plaskens Evans, Kanyile, Adams, and Mene. And then on page 95 of the indexed file, on page 95 of the indexed file, you should be in annexure SET4 by then if you're at page 95. There is an index of a file 7. You see that, Judge? Mm-hmm. Now, if you are at page 95 without covering that page, please page back to the beginning of, that's now page 91. You will see that at page 92, you will see that at page 92, it says file 1 original.
And then it says, a heading in brackets, ACC ERO 14-001270. Paging over to page 93, it's the same number. Paging over to page 94, it's the same number. But then at page 95, the mistake is that it says 002170. And that is the same mistake at page 96, 2170. So the correct number is 1270 and not 2170. I will explain this later. I just wanted to make sure that it's recorded as an errata, as well as...
1270.
Yes, 1270.
Both on 95 and 96. Is it both on 95 and 96?
Yes, Judge. And then you go to page 109. 109 begins an annexure set SETS 6-6. SETS-6. It only reflects one page. And then after that page, 110 goes to set 7. The full complete SETS-6 is in the file, and I want to take you to that page. That is page...
Sorry, 109, what point are you making about it?
Page 109 is a cover page of a transcript dated 2023, January the 30th. What should follow thereafter is then what is transcribed, but it doesn't. It actually then jumps over to page 110 is another transcript. So I'm trying to refer you that actual transcript, the one that ought to have been there, the complete SETS-6, is to be found on page 137 of your bundle. Right. Then, Judge, I again want to record my apology for the faux pas that I had made. I submitted corrigenda about the cloud issue.
I told you I've read your papers.
Yes. So the cloud is gone. I'm happy that the cloud is gone. We can now deal with these issues.
Is there not yet another?
This one is just a clear sky. So, Judge, what are the requirements for a Section 319 question of law?
No, I said you raised certain preliminary issues. Are you persisting with them or not?
Those points in limine? I am.
So why don't we start with your points in limine?
Okay, I can start there. As it pleases the court. There is a purported, I say purported because the court must yet determine it. There is a purported opposition to the application made. It is made by one Cliff Kuzulwandle Lutubezi, who is not here today, on the 14th of June, 2024. Before I proceed on this particular issue, when you were not present at court the other time we were supposed to meet, Justice January managed the proceedings, and at that proceeding, at that appearance, it transpired that the state had actually filed heads of argument. We hadn't received them. As it appears, they filed those heads of argument the very same day that they filed the notice of intention to oppose and the opposing affidavit, the state's answering affidavit. I then indicated that it was not true that they had ever filed them.
and Mr. Marondeze produced eventually a copy, it would appear that they brought the documents to the reception in the correctional facility, but they were not served on us by whomever was serving the papers. So it appears that the only explanation we have, we've looked in the facility, we couldn't find them. It appears that the person who served them did get the date stamp and must have inadvertently just returned with them. I've referred since to in correspondence to the prosecution and to the correctional service that there's a judgment out which indicates that whenever you serve papers to people who are in custody, you should ensure that they are served personally by the person who's actually serving them so that these things can be avoided. I just wanted to correct that Mr. Marondeze must have encountered an intervallus veritas, because there he was telling the truth. I'd like to then refer to these papers. There is a notice. It has a signature. We do not know who signed it. Then there is an affidavit by Cliff Kuzulwandle Lutibezi. All he says is he's employed in the Ministry of Justice, Office of the Prosecutor General. And he says, by virtue of the delegation bestowed on me by the Prosecutor General, I'm authorized to conduct criminal proceedings in any court and to perform all such other functions as may be assigned to me by the Prosecutor General. I'm duly authorized to depose to this affidavit, and I can oppose this application as I now do, and for that purpose, I depose to this affidavit on behalf of the state in this matter, and the facts deposed here to blah, blah, blah. He doesn't show us any authority that he is authorized to do so. Because this is now an application brought on notice of motion. We don't know whether the authority to prosecute cases in general means that anything that arises in a criminal matter, therefore, because you are delegated as a prosecutor, you have the authority to oppose.
Yeah, but you must make your point. What are you saying?
We don't know whether he's in fact, he doesn't show, he doesn't...
No. On the last point, you say we don't know whether an authority to prosecute a criminal trial also means you can deal with everything else that arises. What is your position?
My position is this, that the only person that you can't ask that question to is the Prosecutor General herself. Any other person has delegated authority. We haven't seen that delegated authority. We don't know the bounds and limits of that delegated authority. On what basis, therefore, does he just say, I am authorized, specifically this matter, this interlocutory ex parte application, is he authorized to oppose? We don't know that. The case law that I've referred you to says that, at best, if it's a weak opposition made, and they're just asking authority, you must just tender the proof. That proof has not been tendered.
Sorry, I want to understand you accept that Mr. Lutibezi is one of the prosecutors in the main trial. Do you accept that?
I accept that.
And your contention is that if any application arises in connection with that trial, you will need to be granted another authority to deal with that particular one.
No, that's not the contention. The question I'm making is, does it mean by virtue of him being employed in the Ministry of Justice as a prosecutor of some rank, and they call him a Deputy Prosecutor General, a misnomer that does not exist in any law, does that very fact mean that he's entitled to, when he's prosecuting, any matter that arises in there to raise in defense or opposition or of his own instance to proceed by himself, for example, bringing a reservation of a question of law? We don't know. I do not know what the bounds and limits of that delegation imply. So I'm asking him, on what basis is he
You've got to make
opposing?
your submission. Mr. Shanghala, it's not for me to answer for you. You come to court to say, I contest the authority of Mr. Lutuvezi, isn't it? So you must make your submission that in this particular matter, and let's not generalize, we are dealing with your application under 319.
Yes.
My question was simple. Is it your submission that Mr. Lutuvezi has no authority, even though he is prosecutor in the main trial? Is it your submission that he has no authority to deal with this application?
My submission is the following. Mr. Lutubezi is opposing the reservation of the questions of law under Section 319. He does so alleging that he has authority. He has not shown me that he has that authority. And I say so because I do not believe that by simply being employed in the Ministry of Justice as a prosecutor of some rank.
No, let's deal with this. You have considered that he is the prosecutor in the main trial.
Correct. He's a prosecutor.
Now, the question is, if he is if he is one of the prosecutors in the main trial, is it your contention that he cannot deal with any application that arises in connection with that main trial?
I cannot make that contention, but I can certainly question the authority to ask, do you have authority? And if he has it, all he needs to do is prove it. Tender it in proof. Because the question I am putting in the point in limine is, does it mean that by employment alone, he can take any matter without further instructions? If that is the case, it must be so proven.
You can persist with by employment alone. I am asking you the question where you have considered that he is the prosecutor in the main, in the main criminal trial.
Yes.
And my question is it your contention that even if he is the prosecutor in the main trial, he has no authority or must produce authority when incidental or matters connected with that criminal trial arise?
I didn't make that point. And the easiest point way for me to have made that point is to have simply made that point. But I didn't make that point. That is the court's question, if that is my point. I'm answering the court to say, that is not my point. My point is this. Mr. Lutubezi says he is a prosecutor, he is employed, he is delegated, and by virtue thereof, he can oppose this matter. Show me the proof that in this particular Section 319 application, you are authorized, because I do not know whether your employment means, by employment, anything you can oppose. Perhaps the delegation may say, and revert to me where matters arise. We don't know. I cannot allege that which I don't know. That is my point. That is my point in limine. And the case law says that when delegation is challenged, the easiest thing is to provide it. He hasn't even pitched today. So maybe he's even pulled from the case. How do we not? He's the one who cites, he opposes, he's normally here. Maybe he's pulled from the case. How do we know? Maybe he's even fired. Maybe the Ministry of Justice fired him. So how do we know? So anybody who comes here, dressed, robed, call themselves deputy.
Can I ask this question for the last time?
Judge.
Then we can proceed to the next. I want to understand clearly that while you concede Mr. Lutuvezi is a prosecutor in the main criminal trial, your contention is unless he produces authority that is authorized to deal with this application, then he has no authority.
Or that his authority is wide enough to include this authority and does not require reversion back, then he can't have authority.
You can't put questions to yourself. I put questions to you.
No, I'm encapsulating.
No, deal with one question at a time. My question is, and I repeat, You have considered that Mr. Lutuvezi is the prosecutor in the main criminal trial.
That is a concession.
Right. Now, you have made an application under 319.
Yes.
Is it your contention that even though he is the prosecutor in the main trial, he must produce separate authority entitling him to deal with this application?
No, Judge. Judge, I will go slower. I raise a point in limine. The point is this. By simply stating that you are a prosecutor, and I don't dispute you are a prosecutor, and I don't dispute that you are a prosecutor of some rank, does it mean that the delegation you have empowers you ad general to defend any matter that arises in any case?
I'm not concerned with that general academic thing. I'm
No.
concerned, can you listen? Because I have to make a decision. I'm concerned with whether you are saying he has no authority to deal with this application or not. If you say Mr. Lutuvezi has no authority or has not produced the authority to deal with this application, because we are not talking about the general delegation he might have. We are talking about whether he has authority to deal with your application or not.
You're dealing with the consequence of him failing to respond to that issue. The consequence is that my version must be accepted, therefore, that he probably doesn't have authority. But you're not stating the question that I posed. You're stating a question now that you want me to pose. The question I pose is clear. It's in my papers. I stand and fall by that. I can't take it any further. The consequence is that if he doesn't prove it, he probably doesn't, he's not even here himself. Mr. Marondeze can say and stand up and say, I know I was with the Prosecutor General today. He is delegated to defend his authorized. But that, I don't know, it's hearsay.
What do you say about Mr. Lutuvezi's authority to depose to an affidavit in opposition in this matter? What do you say?
I say that...
Is he the authority according to you or he doesn't?
If he doesn't show it, he probably doesn't have it. He doesn't have it.
Your submission,
Either specifically...
Your submission is that he's not entitled to...
My submission... Judge, you're turning me into what you want me to say. I
Look,
keep telling
if
you...
you want to argue with the court, that's up to you.
No.
I'm trying to guide you, Mr.
Yeah.
Because you can talk about the generalities.
No.
Whatever you may want. I have to deal with specific issues.
Yes.
I have an application by yourself.
Yes.
You are saying that Mr. Lutuvezi
Yes.
has no authority to deal with this application. Is that not so? If he has the authority, then we proceed. If you say he has no authority, then we deal with the preliminary point. If he has the authority to answer to this application of yours, then he has the authority according to you. If he doesn't, then say so.
I'm saying, Judge, in keeping with the case law that I've read, if a person says that they have authority and it's questioned, they should prove it. He hasn't proven it. My version should be accepted.
To do what?
To oppose this specific application for Section 319, questions of law to be...
In other words, if he, according to you, if he can't produce that authority, then it stands to reason that he has no authority to deal with it.
You see now why I'm saying, Judge, that's now the consequence of my point. We are now together. That is now the consequence of my point. That is what the court would have to find. That's not what I'm saying. The court will determine. I can't determine. The court will determine, looking at the facts before it, and say, this is more believable. Do you believe Shanghala, or do you believe the paper by the person who's not here?
All right, you can proceed.
The second point in limine is that the very notice itself is signed by somebody who purports to sign PP on behalf of the Prosecutor General. The person's name is not put on that paper. I do not have a database of signatures that reside in the Prosecutor General's office to know that this is indeed so-and-so's, but I compared it to Mr. Lutubezi's signature. It's not the same. I don't know who signed it. Because if the person says, I have authority, then why don't that person just sign in the person's name because you're delegated? You sign, I, so-and-so, sign per procurationem, because I'm empowered to do so. There's nothing. It's just a paper scribbled. For all I know, it could be a cleaner who signed it. Do they have authority because they're employed in the Ministry of Justice as a cleaner in the Prosecutor General's office to sign documents? These are the issues. It's not trivial. It's a very important issue. This is an important case, I would think. So you'd want to have the delegations and the authorities properly stated. It's just a paper. We must just take it. And I say there that perhaps here you have a Prosecutor General who doesn't even know that this is going on. Because I've delegated, in that case, power and authority to go, I don't even know what's happening. Because the Prosecutor General can at any time withdraw that delegation authority. So I need to know who signed that piece of paper. It's the first time I've seen it. Any other time, Mr. Marondeze will sign something, or Mr. whoever it is will sign something. But this one, it just has a scribbling. It's thrown in there. I don't know. So is that notice of opposition in the first place even valid? That's the question I'm putting. And that's a point in limine. If the court finds...
Your position is the notice of opposition is not valid, isn't it?
Excuse me, Judge?
Your contention is that the notice of opposition is not valid.
It's not properly filed. We don't know who did it.
Is that your contention, Mr. Shanghala?
Yes, my contention is it's not properly filed. Therefore, there is no opposition. Doesn't matter if you have an affidavit if there's no opposition. Maybe the court can condone then that there's no opposition and the affidavit maybe says that's the valid thing, but if we go stricto sensu, there is no opposition. That is the contention we make.
You can proceed.
Right. Having disposed of that, Judge, I wanted to move to the requirements for Section 319, questions of law to be reserved, stated, specifically recorded, and then transmitted to the registrar. I've given you the case of Magidela and another, 2000, in brackets 1, SACR, which has been referred to also in the case of the DPP.
Let me understand you. Are you going to deal with the opposition filed by the state or not?
I will. But first, the opposition must be put into context. The application that I'm moving is, I want to first state that it complies with the requirements in the Act and in the case law, then I deal with the opposition. Or should I first deal with the opposition and then I can deal with the requirements later? You've read the paper, so... Yeah,
I've read it. The reason why I'm saying that the state you are in a little invidious position. But anyway, let's assume we are not. But the state's main opposition is what? To this whole application?
The state raises, in one paragraph, a number of points, all lumped in together. The state says the procedure adopted is wrong, in paragraph 5. Then the state says Section 319 can only be invoked at the end of a trial. The third point the state makes, in its very paper-thin submission, is that we ought to have appealed the ruling of the court, and then it dog whistles at the end there that we're just delaying the trial. Those are the 4 issues that you can decipher from that paragraph. Now, Judge, I want to deal with them in that fashion. Let me start with the issue of the procedure adopted is wrong.
Yeah, you see, the reason why I say that that opposition, if you are dealing with it, is critical in that in the respect that if the point is valid, that your application is premature, then that would be the end of the matter, isn't it?
Yeah, that's one of the points they raise. But I was going to take you through the requirements.
Yes, you will, but I'm just wanting you, like you have agreed,
Yeah.
that opposition contained in paragraph 5
Yeah.
is dispositive of the whole application if it succeeds.
If it succeeds, not if it's correct. I definitely know it's wrong. But if it succeeds, it doesn't matter anyway.
It would dispose of the whole application.
Yes, if it succeeds, but it remains wrong.
Yeah, okay. No, that is quite fine. That's your thinking.
Yeah,
But
no. You see,
Let me finish off. That is why I'm calling upon you to deal with this point.
Yes.
Because I suppose that if the state is correct or if their point is upheld, that is the end of this application.
if the judge agrees with them, with their wrong position, then that is the consequence of that agreement of the judge, regrettably. But I really hope that the
It's
court
not
will
a
listen
judge
to my...
a judge doesn't agree or a judge makes a finding.
Yeah, because he alleges that if the court concurs with him and finds that he's making a better argument, even though it's wrong, I rely on certain judgments, and I'm going to refer you to them. And he relies on two cases, one by Judge President Stradom in 1992, the Pinheiro case relating to those vessels, and one relating to Ndala. It's actually cited as Malumo, which was done by Judge Hoff, and he was wrong. Well, not necessarily that he was wrong, he was stating the law then. And I want to refer you to other cases. So I was saying that the requirements made out in Section 319 do not speak of a procedure. That's the point I had made earlier. They just entitle you to raise a question of law. But they don't speak to procedure. In fact, the case I give is the case of Nelumbu and others versus Shikuma and others. It's a SA 27 of 2015, Namibia Supreme Court case 14, determined on 13 April 2017, that if you bring an affidavit in your motion proceedings, they serve the process of advancing the pleas as well as the evidence. And so I can't understand when he says the procedure is wrong. He doesn't provide any substance to the allegations. It's just an allegation pulled from somewhere and plunked onto the piece of paper. It's gibberish. I don't understand it. Then I move to point 2. Apparently, they may only be invoked, Section 319, may be only invoked at the end of a trial. Now, this is where I want to refer the court. First of all, I've given you, Judge, a copy of the Malumo, S versus Malumo and others, in re Ndala and others, versus the state and others, in brackets 2, CC 32 2001, in square brackets 2013, a high court case, 262, determined on 19 September 2013. And the case of Pinheiro that they rely on, SV Pinheiro and others, 1992, 1 SACR 287, Namibia. They're quite distinct from what is happening here. You see, in the Malumo case, there was a prosecution of certain persons in this court for declaratory relief relating to the jurisdiction of the court. But that was not a Section 319 brought, well, let me just explain. There was an application they brought that was struck on the basis, relief was sought on the basis that in terms of Section 106, 1 sub F, the court has no jurisdiction under the Criminal Procedure Act. That matter was determined, disposed of, and after it was disposed, when they came to court without notice, counsel for the applicants framed questions and threatened a civil case to challenge the jurisdiction of the court, etc. And then the court held that no, this was an abuse of the procedure, and then it was refused. There were not proceedings with that trial. In Pinheiro...
Sorry, in Malumo, did the court say anything in relation to the issue raised by the state?
Yes, they said that those questions of law are only raised at the end of the trial. And the court relied on Magidela and Mahmoud. I've also given you...
Just a minute. So Malumo says your Section 319 application must be brought after the completion of the trial, correct?
Yes, that's what they say. Relying on case law.
Yes, whatever. But that is what the law, Malumo says, isn't it?
That is what Malumo said. Mm-hmm. That is what Pinheiro said. But I'm distinguishing those cases from this year's application. I will explain to you just now, Judge. That those cases, when they were brought just to follow the old jurisprudence. They did not raise questions of law in the manner that we are raising them now. First, Malumo, it's important to realize that the question of jurisdiction was determined in a Section 106, 1F plea. It was disposed of. The court then found that this is an abusive process. In fact, almost sanctioned that legal practitioner. The proposition is this, that because Ndala and Pinheiro said that questions of law are only raised at the end of the trial after conviction or acquittal, this is not the right time to bring these questions of law. That is what the state says in that paragraph 5. And I'm saying, but with the greatest respect, that is very narrow. I refer the court to the judgment I have given to you, 134 pages of it, of Basson. Dr. Wouter Basson was an operative of the apartheid CPC regime.
Can we get to Basson? Draw my attention to the particular paragraph where they make the point you want to make.
In Basson?
Do you have the Basson there, registrar?
So, 115. One of the consequences of the advent of our constitutional democracy.
This paragraph.
115. But the index in front of Basson gives you a better. In fact, Judge, if I may, let me give you all the paragraphs that are relevant, actually.
The Basson case you are talking about, is that the Constitutional Court case or which one?
Yes, there are 4 cases of
Yes,
Basson.
I'm asking the question is, are you referring to the constitutional case?
Yes, Judge.
Yes.
And I want to explain to you that there are 4 Basson cases. There is,
I know, don't worry, Mr. Shanghala, we are not in a classroom here.
no.
I know there are a number of, that's why I'm asking you, are you referring to the constitutional court case?
Yes.
So that we go to the paragraphs you are talking about.
In the Constitutional Court,
Yes.
there are 3 judgments of Basson.
Mm-hmm.
I'm referring to the one that I've handed to you, the one that deals with,
CCT
03.
30
yes,
of 03.
yes.
Okay.
That one is the one that refers to the issue of the bias of the judge and the Section 319 application, which was determined now by the Afrikaans judgment of the Supreme Court of Appeal in Basson, and the 5th case being now the High Court judgment. That's just the explanation I wanted to give. But the particular part that Basson at paragraph, I don't know, maybe you use a pen, Judge. It's easier for me to navigate here. It starts roundabout at paragraphs 100 and 135. From paragraph 135, because in Ndala, reference is made to R.V. Adams, a 1959, I think, or 53 case, which related to the Criminal Procedure and Evidence Act of 1917, where that section then makes that whole transition. So Ndala stated the law, perhaps without the knowledge that that law has been interpreted differently. It's the same law. That Section 319 in South Africa is today what it is in Namibia, as it was in 1977, as it was the copy of the 1955 one, as it is amended with some changes, commas here, and the name of the Superior Court to the Appellate Division from the 1977 legislation, as it was amended in 1948. It is the same case, same section. Therefore, I commend that jurisprudence to you because we share that legislation, and before independence, those determinations of the Appellate Division form part of our common law. When the court in Ndala, let's say it's Malumo, in Ndala, when they made that determination, they were oblivious, I'm sure, to Basson and the exposition contained herein, where the court then goes on to say that you cannot say that 319 questions can only be brought after a conviction or an acquittal. The reason is this. The powers of the DPP to prosecute, in this case, the Prosecutor General, stem from the Constitution. You have to read an antique legislation with a constitutional lens. You cannot just read it as it stood in 1917, 1955, 1977. It will go against the grain, the constitutional values and aspirations. Because what you would then do is fetter the constitutional powers of the PG, duly empowered under the Constitution to prosecute in the name of the state, to say you can only prosecute a Section 319 question of law after a conviction or acquittal. In South Africa, that is not the case. I commend the court to that jurisprudence and say that let us rather take the view taken by the Constitutional Court in Bank. And I want to just give you that it was the full Constitutional Court, not one of them disagreed. We have the judgment of Judge Hoff here. It doesn't bind you. It's
Right, Mr. Shanghala, it would do us some good if you directly answered my questions. You have submitted that S. Malumo and Pinero, isn't it,
yes,
are to the effect that the Section 319 application is brought at the end of the trial,
yes,
after conviction and sentence.
yes,
All right? And you say Basson is to a different effect.
yes.
And I asked you, can you just read out, show us the page in Basson, because you are going all over the show now. All I wanted is go to Basson, tell me, show me in Basson the paragraphs where the Constitutional Court of South Africa made a contrary observation.
So maybe, wait, sorry, I don't get it. Am I understanding the judge to imply that there actually wasn't a contradiction by Basson?
Sorry?
Is the judge telling me that there isn't a contradiction of Basson to the position of
No,
Malumo
I'm not
and Pinero?
implying anything. You
Oh,
already,
okay.
Because look, this is a 130-page judgment.
Yeah.
Your task, I know you are not practicing, but your task is to make the judge's job easy. Judge
Yes.
Basson in the Constitutional Court case at paragraph so makes a different point from Malumo and Pinero.
Yes.
That's all I wanted.
Okay. At paragraph 138,
138.
this is what the court says. The rule that you only do it at conviction or acquittal has been followed in a number of subsequent decisions in the appellate division. Significantly, though, not without reservations. That already is an important point, Judge. Significantly, though, not without reservations. Then it continues. In S versus Mene, it was accepted that section 319 is capable of another construction, and that the one given in the Adams case has resulted in a lacuna. So the Constitutional Court is saying, when you read section 319, it can not only be the position that has historically been held with Adams, which is what Malumo relied on, which is what Pinero relied on, that you can only bring it at the end of a conviction or an acquittal. So the Constitutional Court is saying, in S versus Mene, it was held that you could have another view. I'm preferring the other view now to this court. Then we continue. S versus Mene was decided in 1978. It's part of our common law. Then, at paragraph 140, the judges then say, this is the proper construction of 319. As I said, this 319, we inherited it from South Africa, colonial period. The owners, this is how they interpreted it.
Your paragraph?
140, and I'm moving you to 141. One of the consequences of the advent of our constitutional democracy is the requirement that all laws must be construed in the light of the Constitution. This requirement flows from the supremacy of the Constitution. Judge, for one moment, you could think that this person is talking about Namibia. It is thus axiomatic that where possible, legislation must be construed in a manner that will bring it within the constitutional bounds. Thus, when legislation is capable of more than one possible construction, the one that brings the legislation within the Constitution ought to be preferred. This is the principle. In dubis, you prefer benignoria praeferenda sunt. That is what I'm trying to tell the court. Then we go to Daniels. When dealing with older legislation, old order legislation, this interpretive injunction may require courts to depart from a construction previously placed on the legislation. Now, this is the absurdity. And this is why I'm saying maybe the PG is not the one defending this matter. The court says in Basson, you cannot take the view that you can only bring it at the end of an acquittal or a conviction, because the prosecutor
has powers from the Constitution. That's where they stem from. If you take that interpretation, it means you've gone and inhibited these constitutional powers. Judge, okay, Judge. I will help the judge. At paragraph 147, the judge now starts with a historical explanation. He says, the amendments introduced by the 1948 Criminal Procedure Act, which I had told you before, were no doubt intended to address the legal position that prevailed prior to the amendment. That position was that the prosecutor could at no stage request the reservation of any question of law at all on behalf of the state. The amendment altered this position by allowing the prosecutor to request the reservation of a question of law on behalf of the state. This legislative history of Section 319 makes it clear that it was intended to afford the state the right of appeal, a question of law, to the Supreme Court of Appeal. This right is incidental to the state, to the right of the state to institute criminal proceedings provided for by in Section 179(2) of the Constitution. But was it intended that this right be available only in limited circumstances? Then he goes to 148. There are indications both in the language of Section 3191 and in the context in which the section occurs that this was not the case. If ever, Judge, you're looking for it in black and white, it couldn't be clearer in black and white, even if I had 3 sets of spectacles. Mr. Marondeze, you are with us. I want to give you, I'll give you. I'm just rushing. Did you not get a bundle? Oh, thank you. Oh, my apologies, Judge. I thought you were still engaged. Judge, I was saying that I was teasing Mr. Marondeze, saying that him and I have eye problems, that even if we wore 3 of his sets of spectacles, it's clear here. And then I'm going now to 149. No, actually, let me stay in 148. There is nothing in this language to suggest that the state may only request the reservations of questions directed at the conviction or acquittal of the accused. There is nothing in this language to suggest that the state may only request the reservation of questions directed at the conviction or acquittal of the accused. If you now understand the history, which you didn't want me to get into, it was made for the individual. Now, the court is coming to say, Section 3192 indeed strongly suggests that the legislature intended to permit an appeal against any order upholding or dismissing an objection by way of a reservation of a question of law. The subsection provides that the grounds upon which any objection to an indictment is taken shall, for the purposes of Section 319, be deemed to be questions of law. In holding that a question of law can only be reserved at the conclusion of a trial, the court, that's the Supreme Court of Appeal, in Adams relied, among other factors, upon the long-established legislative and judicial policy, which precluded piecemeal appeals to the appellate division. The problem of midstream appeals, and then it goes on. I want to take you again to 150. The effect of the Adams rule is to take away the right of the state to appeal against an order of the High Court upholding that an objection that a charge does not disclose an offense of law. Then I take you to 151. The effect of the Adams Rule is not only to prevent the state from instituting criminal proceedings where a court quashes an indictment on the ground that it does not disclose an offense, but it also takes away the right of the state to appeal against a decision upholding an exception to its indictment for another reason. Such an interpretation of Section 319 is inconsistent with the right of the state to institute criminal proceedings and thus with the Constitution, the point I've made. Then I continue.
Right. The point is made in relation to quashing of an indictment, isn't it?
The point is this, Judge. The state opposes and says it can only be brought at the end at an acquittal or conviction. They rely on Malumo and Pinheiro. I distinguished the cases. Then I said, this section has a history, a legislative history.
Yeah, you don't have to repeat again here. My question is this. Is it a correct understanding of what is stated in Basson and another case which you cited
S versus
also?
Mene.
Huh?
S versus Mene.
Yeah, Mene and the other one where it is a little clearer.
Bookhold.
Yes. Is it a wrong understanding of those cases that insofar as they relate to subsection 2, is it subsection 2 which talks about an objection to an indictment?
Yes, which are questions of law, yes.
Yes. That there can be a departure in that regard.
Yes,
when you are dealing with an objection to an indictment.
No. Bookhold, fine and well, that particular point I read to you, I read it to you for the purpose of saying Section 319 can give you a different interpretation other than the one to say you can only raise these issues, any issue, at the end of a conviction of a...
My question is with respect, assuming I agree with you, right? Yeah. If you listen carefully, my question is, does it extend to every kind of question of law or a question of law arising from the quashing of an indictment?
The Constitutional Court was very deliberate, and it put a heading, the proper interpretation of this section. It does not make that type of distinction. It says 319 will be interpreted as follows. It does not mean it can only be brought at the end or of a conviction or an acquittal.
So apart from one indication, is there any other indication they pointed to? That is the indication arising from subsection 2 of 319.
Yes, because in the Bookhold case, and I've also given you that case there. I want to refer you to what that Supreme Court of Appeal says about Basson. Apologies, just bear with me, judges. Says at paragraph 31 of Bookhold. At paragraph 31 of Bookhold, it's not in the bundle, it's one of the ones that I just gave you today.
Don't worry, I know what I'm looking for.
Oh, sorry, my apologies. At paragraph 31, again, the full bench of the Supreme Court of Appeal say, before the judgment of the Constitutional Court in S versus Basson, this court had repeatedly held that a question of law could only be reserved in terms of Section 319 of the CPA. Upon conviction or acquittal of an accused, and that an order upholding an exception to a charge was neither a conviction nor an acquittal, and consequently could not be reserved for the consideration of the court. So what it's saying is this. The Supreme Court of Appeal said, you're dealing with an exception. It's not a question of law because it's not dealing with an acquittal or a conviction. Because you can only bring a question of law at an acquittal or a conviction. Basson is saying, no, that's not correct. Boekhout is saying, the position after Basson is that you can bring it at any time. And
Yeah,
I
but,
refer you to paragraph 31.
When I invite you to make submissions, if you narrow yourself to the question, it helps you. My question is simply this. Basson and the other two cases, right? Are they not only, or would they not be acceptable only in relation to a point of law arising out of the quashing of the indictment under 3192?
I understand the question perfectly.
Right.
And I want to respond to you as follows. The Supreme Court, the Constitutional Court in South Africa did not confine itself in its interpretation to only the issue of the quashing of a charge.
That's why I asked you. They said there are some indications. Is there any other indication as to the proper construction of that section 319 other than the one raised in subsection 2?
Yes, I've given you S versus Mene, which the Constitutional Court referred to. And it says, dealing with, and S versus Mene didn't have to do with the quashing. It had to do with the question of law being reserved. It says, you can have another interpretation. It then interpreted it in the light of the Constitution and said, if you interpret it in the manner that is being interpreted by the Supreme Court of Appeal, then you are now against the Constitution itself. Read that old legislation in the context of the Constitution. So I'm saying, when Malumo was determined, when Pinheiro was determined before Basson. Malumo was determined, I believe, with the ignorance of Basson. It just wasn't raised. It wasn't brought to the attention of the judge. And I'm saying that that interpretation in Malumo does not bind this court. It's horizontal. And secondly, this Constitutional Court interpretation was made by the court in Bank, by Chief Justice Chastelson, Langa, Madala, Mohoro, Moseneke, Tobo, Reagan, Sachs, Squaya, Van der Westhuizen, and Yakub. It's a full bench. We have a single bench judgment.
That judgment remains of persuasive value no more.
Correct. And yes. I'm saying, because of the historical legacy and the constitutional article that says that the pre-independence legislation remains in our legislation, and in that jurisdiction, where it comes from, it has been dealt with this way. Who are we now to go this way? I'm saying let's follow what the people are saying. That is more progressive. And if you interpret it in the light of the Constitution, you get to the Latin maxim of in dubis, then you follow what is benefiting. Because if you determine that question of law, and then the question of law I ask itself, question I think 3, brings us back, it underscores that interpretation which is beneficial to my human rights of a fair trial. And that is why I beseech the court to not follow the single bench judgment, which I am pretty sure if it had been brought to their attention, they probably would have changed their mind, of Hoff, who says it can only be brought after a trial. Take it in the context of where Hoff was raising it, because he had just dismissed a 106 1F plea of lack of jurisdiction. In Pinheiro, they were dealing with the state sought to confiscate and seize assets, not in terms of the CPA, but in terms of the Sea Fisheries Act. And the court directed them to that legislation. Those are different scenarios. In here, I am asking questions of law before we even proceed to say, and I can go into the questions. Those questions of law, I would still like to be given an opportunity just to make sure that I have adequately motivated them. That is a distinction. So the third point the state makes, if I may move on, Judge. I hope it pleases the court. I will move on.
Just a minute.
Okay.
So you are saying we must take an interpretation that is wider than confining the sentiments of the South African courts to subsection 2.
I'm saying...
You are saying it must be wider.
It must be wide, but I'm also saying, Judge, Basson doesn't limit itself to subsection 2 because he refers to Mene. Mene doesn't limit itself to subsection 2. It says 319 may be given a different interpretation. 319, not 3192, 319. I want to go back.
No. I'm aware of that. I'm aware of that. Don't worry.
Yeah.
It says it may be given a different interpretation, correct?
Yes.
But the question was, do we have case authority which actually gives a different interpretation, except in relation to 319 subsection 2?
No, the cases that I have found, and I've given you Magidela, and I've given you Schoolman, did not deal with the quashing of the charge.
Did Magdala and Schoolman say that it can be brought after?
No.
Before the completion of the trial?
No, the cases on the issue of it can be brought any time is Basson and Buchholz. The other cases deal with other issues. So, quite right, what you want is to know if I can refer you to another case that says, can it be brought before that? Before Basson, no. The Constitutional Court then determined, and then Buchholz follows in that line.
Buchholz,
yeah.
Yes. Talks about subsection 2, isn't it?
Excuse me, Judge?
Buchholz talks about subsection 2 of 319, the indictment, quashing of the indictment.
What happened in Buchholz, Judge, was that Buchholz raised the plea of lack of jurisdiction.
Yes, I know. Just answer my question. Does it not deal specifically when considering at what stage do you bring a 3-1 application? Does it not talk only of the quashing of an indictment?
No. What Buchholz does is this. In Buchholz, he raises a plea of Section 106, just like Malumo. He then succeeds. He then gets prosecuted. The state then raises a question of law and says that he was wrong, the court was wrong, not to allow them to, first to find that that he lacked jurisdiction, and then to find that the question is whether as a question of law, wording the wording of Section 2 as well as the definition of racketeering, no, not that one. Yeah, in fact, at paragraph 27 of Buchholz, on page 8, question 8 is framed in a broad and somewhat curious manner. Whether, as a question of law, the power of the High Court to develop common law becomes a duty of, because of the interest of justice principle envisaged in 173 and because the constitutional duty of the state to effectively prosecute.
All I was wanting is to deal with the Buchholz case, whether they were dealing only or they made the observation was made in relation to the quashing of indictment only, or it was wider than that. Because if you go to paragraph 33
of Buchholz.
Yeah, and if I'm correct, And perhaps starting at page, I'm not asking you to read it, but
yeah.
Paragraph 32 and 33, they seem to be dealing with the question of the quashing of indictment. But anyway, I think you have canvassed the point sufficiently.
Yes, but Judge, I need to make this point. You remember that I said at the beginning that these questions of law would have never arisen had we not left pre-trial and gone into the pleas. If these questions of law are determined and we are back into pre-trial, like in the Basson case, we have raised issues in the status reports and the pre-trial memoranda which relate to the evidence, which if dealt with pre-trial and pre-plea has the effect of quashing the charges. So nothing turns on the specificity of Basson per se. In fact, it is on all fours with our situation of Basson. If we go back to pre-trial, we will deal with the issues as we thought they ought to have been dealt with, which will quash the charges before the trial begins. And that is why I say, in dubi, praeferanda benignoria sunt. When there is doubt, favor the position that is less cumbersome. In dubis pro rea, in doubt, favor the position of the accused. Because that is the person who faces the full might. Now, if you just go into trial, in Boekhout, by the way, 2 years of that case, 10,000 pages. We start here with 165,000 pages. If I do a factor, it means I'll be in this court for 16 years. Why should I be locked into that when we can dispose of the issue now? That is what I am trying to get to. Let's deal with that evidence, which we say was unlawfully obtained. Why should the court come and prosecute me on charges, on evidence which is unlawfully obtained? That is the issue. I want to get back to the pretrial. By moving into the plea, I've been denied. Hence, I raise those questions of law. Hence, I want to go to quash those charges. So, the issue of Basson, whether or not it dealt specifically with that or in general, or this case, we are on all four. We run around all four corners of Basson like it's a basketball court. We are within Basson and Boekhout. I want to move on to, if it pleases the court, to the third point.
Are you done with paragraph 5 of the opposition?
No, I want to move on to the third point that they made. And that point that they made is that we should have appealed the ruling of the court. That is what they say.
Which ruling?
That is exactly the question. You see, the court made a ruling and said, I will not determine any application until the pleas have been taken. I will not determine any application because there is a cloud hanging over my head.
I think you are mixing two things there.
No, that's the...
Yeah, but it's not argument, because you have to make me understand what you are saying.
What I'm saying, Judge...
If I'm saying you are mixing two things, deal with one at a time.
I'm at point 3, Judge, where the state in paragraph 5 says that I should have appealed the ruling if I'm not satisfied with it. I cannot bring section 319 questions of law. And I'm saying that the ruling that was made, the rulings I recall, are the following. I cannot deal with any application until we have pleaded. After the plea, bring your applications. The other one was, I cannot deal with any of these issues because there's a cloud hanging over my head. That's what I can recall. Now I'm responding to those.
These rulings were made because we now delve into the area of facts. The first ruling was made when?
Regrettably, Judge, I'm unable to give you a date. I've requested the record. I have not yet received it. To the extent that perhaps the court would like to first be addressed on whatever was particularly uttered in court, maybe that point can be entertained afterwards. We can get a court order to get the record, and then we can address you on that. But what I do recall is that also in the judgment relating to the recusal, the judge makes a statement and says that if you are not happy, you could have appealed the ruling. Mr. Marondeza made submissions in court to that. I think I recall that lucidly. I then see language in paragraph 5 which triggers my memory to those utterances and those rulings of the court. So I confine myself to that which my memory recalls.
But you are the one who argues that there was no ruling.
That is the point I'm making. I'm making the point that there is no appealable judgment or order. Rulings are not appealable. Because if you say that that ruling is appealable, I didn't even have the opportunity to advance arguments before the court before it can determine that ruling. That is the point I'm making. And I refer to Shetu Trading, CC versus the chair of the Tender Board of Namibia and others, 3 SA 26 of 2011, Namibia Supreme Court 12, 4 November 2011, by Justice O'Regan.
I just want, Mr. Shanghala, I've read all that, and I have no problem with the issues you raised there. Yes. The rulings referred to here are which ones? I just want to be clear. You said the first ruling was no application to be entertained until plea taking is complete.
Yes.
That was the first ruling. I don't know according to who, but you say there was no ruling of that nature.
I'm saying, according to my...
Applications.
Yes. Judge, I must make a caveat here, and I want it recorded, that I cannot purport to amplify the answering affidavit of the state. It is scanty. It is one paragraph. In fact, I don't want to be dramatic, but I will hold it up.
I have it. I have it. I have it.
Yes.
So there's no need to hold it up for me.
My apologies, Judge. I want to refer you in your judgment to the paragraph in question that I made reference to. Once you find it. So I was saying, Judge, I want to have a caveat recorded that in this, all he says is, and I quote, a litigant who is dissatisfied with a ruling made by a court is at liberty to exhaust his right to appeal the matter at its end. Oh, sorry, let me start rather here. It was open for the applicants when sanctioned by law to appeal against any of the rulings of this honorable court which they were discontent with. A litigant who is dissatisfied with the ruling made by a court is at liberty to exhaust his right to appeal the matter at its end. However, he's right, and then I end the quote there. So he doesn't necessarily state which one, but by necessary construction, I go to your judgment in the recusal at paragraph 24. This is what the judge says. At the commencement of the proceedings on 8 December 2023, Mr. Bierkes was not in attendance. Mr. CEO Munji advised that Mr. Bierkes was booked off sick from 6 to 22 December 2023. This was confirmed by accused 4, who handed in a sick note from a medical doctor. Accused 3 indicated that he wanted to make an application in terms of section 3191 of the CPA. In response to accused 3, I stated that the court was to proceed step by step and continue with the plea taking, and I would entertain applications of any nature after the plea taking. This is verbatim from what the judge said, Judge Moses Chinhengo. That is what I can fathom to be what the state is relying on. But I cannot be amplifying their papers. They are scanty. They have no version above upon which they place this allegation. On the basis of accepted rules, Plaskens Evans, etc., and another one, that shelf code, the one that I referred the court to, my version should be accepted. It was the case of...
No, all that I've read,
Okay.
that's almost trite law.
Yeah.
The version of this one, that one,
Yeah.
Pascon and Evans, and so on and so on.
Yeah.
All those cases don't present any difficulty.
Wonderful.
Let's deal with the specifics of this. Is there anything else you wish to say in respect of paragraph 5?
Yes, they've made 4 points. I've dealt with the 3. And then I told you that there's the one at the very end, tail end of that paragraph, where they dog whistle. They say that we're delaying, this is just a delay. I would now like to deal with that issue of this is just a delay. They actually use those words.
You have covered it extensively in your submissions, isn't it?
In my written submissions. And would you not like me to just highlight 2 points?
No, I would like you to highlight, but not to go through the whole argument.
Yes. Judge, that is the crux of the issue. The crux of the issue is that the conduct of the state, in this case, has been to delay, and delay. As I speak here, Judge, I want to give you precisely. I have now been in detention for 4 years, 7 months, 29 days, and since I was arrested at 6 in the morning, depending on the time now, it's probably 6 hours, minutes counting and seconds going. These people arrested us and then started to investigate. These people say this, 4 years, 7 months, 29 days in the hours, that's 1,703 days. Every time the court remands me into detention, it adds to these days, based on the conduct of the state, which is delaying. And I want to now show you how they've been delaying this case. Because, you see, I recall when you came, Judge, you said, we need to start at some point. People have been in detention for a long while. I want to see now whether the court is actually meaningful in those statements or whether it is what is called in English lip service. Now, You may recall, Judge,
what point did you want to make?
that I'm not delaying.
You want to make the point you have made in your submissions that this application is not causing delay, isn't it?
First, maybe that, let's first.
Am I wrong? You make the point that your application does not occasion delay. Actually, it might curtail the proceedings.
Yes, because the state is saying...
because bit, wait. Your basic contention is your application is contrary to what the state is saying, actually likely to speed up the resolution of the criminal trial, isn't it?
100%.
Yes.
Is
there anything else you want to say in that regard?
Yeah, there's quite a lot, Judge, what I want to say. Because the state says it will only result in further delay of the trial. I want to say no, and I'll give you an example why. Why, if these questions of law are determined, it will not delay the trial. First, Judge.
You want to go through?
No, I don't want to go through.
Mr. Shanghala,
I don't want to.
You see, in application proceedings of this nature, I need to remind you, you have filed your founding affidavits. You have filed your submissions, which you say you stand by. You have made the point that in your submissions, you have made the point that actually this application of yours is not going to cause delay, isn't it?
Correct.
Against the state's position, which has not been amplified, isn't it? Against the state's position that this is merely to cause delay, isn't it?
Correct.
And I've allowed you to highlight whatever else you think I need to consider outside what you have stated in your papers.
That is not correct, Judge. You've allowed me to highlight whatever is not stated in my papers relating to the 3 points made by the state in paragraph 5. Paragraph 5 has 4 points which I took out. They probably have more, but we will never know. The fourth one is the delay. As I commence to argue it, you are saying I'm standing by the papers. You don't want me to, if I just pick up my file, you don't want me to, I don't know now.
No, I am saying, are you satisfied with the written submissions you have filed, which I've read?
I'm satisfied, but I want to highlight 2 issues.
All right, can you highlight the 2 issues?
Thank you, Judge. The first one, Judge, is that it is the state that has been delaying. First, when they disclosed the first time, they didn't disclose everything. That first disclosure was made on a day in April or May 2021. We were given 80,000 pages. Then they disclosed again in June 2022, 20 files, approximately 15,000 pages, including that Deloitte report, which is not an audit report. And then on 1 June 2023, 40 further files were disclosed, 40,000 pages. And as I told you previously, 15 February 2024, after we had started pleading, they disclose. Not small disclosure, 30,000 pages. Now, I wanted to take you to that annexure that I was showing you at the beginning and correcting. SETS I think it's 4. SETS, SETS 4, 3 and 4. If you SETS 3 starts at page 87. SETS 4 starts at page 92. Both purport to be Well, SETS4 was our handiwork trying to
Just
compare.
say page, please. Page
The index, page 87,
87
and page 92. One needs to compare those two pages. On page 87 in SETS3, it says file 1 and it says case file ACC error 14001270. It says there, if you have the correct one, it's the one with the date stamp of 4 December 2023 by the Prosecutor General. It says SN and then documents in the second column and ref in the third box. They have various documents listed to 22. Document number 3 is a letter to the DGACC. DGACC refers to Director General Anti-Corruption Commission from Attorney General dated 9 September 2015. Yours truly. Then there is a 7 case file reopen note of N. Becker to DG. N stands for Nellius. He's now a commissioner at the police, formerly at the ACC, responsible for investigations.
What's the point you want to make about 92 and 87?
If you go to 92, it is blank. You only have the document, an affidavit of Stephenson, annexes JS1 to JS39. This was disclosed at the beginning when the disclosures were made in 2021. The one at page 87, is what was disclosed on 15 February 2024, this year, which means they held back documentation, including the ones that showed that I was actually helping the investigation, make the allegations that if we are allowed out, we'll go and interfere with the investigation, the one who's helping you. How will this cause a delay? Because, as I told you, 30,000 pages had arrived. Can we really proceed with plea taking when I need to first investigate what is before me to know how to plea? My apologies. Short water. Secondly,
So you're simply saying that that's one and the same file.
actually, they say it's the same file, so the same file should contain the same documents.
Yeah, what I'm saying, your point is the disclosure in 2021 appearing at page 92.
Yes.
With the annexures JS 1 to 39 is different from the disclosure at page 87.
You hit it on the head. The real file is this one that was disclosed this year. In that file is where you find Bobo Kathindi's complaint, the one that triggered all of these issues, the one of Namsov. It shows you what this issue, this case is all about. It's about a company fighting for quotas, trying to get rid of a minister, recording him in meetings. Everything is there. The board meetings, it's there. And then we are delaying the trial. They are withholding evidence. Another issue, Judge. They seized documents from my house. They gave us a disclosure of what documents are taken. I sent 3 different people to go into my house, look for the file that has certain documentation which was in my office when I resigned days before I was arrested. It's not there, which means they took the documents but are withholding them. They are delaying the case. That's one example. I want to move to the next example of how they are delaying the case. In this court, I made a remark, or perhaps it was Muroro, but I think it was me, to say that how are we going to continue when in South Africa, Maren de Klerk the issue of his bail, etc. And then Mr. Marondeze theatrically performed here. It's another case. It's got nothing to do with this case. Nothing at all. They are not honest with the court. This is, let me tell you, this is what, and it's part of the evidence, this is what they've said themselves. I want to refer you to page 66 of the bundle.
You mean the paragraph where you say that, where he says without Marion de Klerk, the other accused cannot be, there will be no case against others?
Yes.
Yeah, that's why I'm saying I've read it.
But not only that, I wanted to refer you to page 66 of this bundle. It's an affidavit by Andreas Ndeshpanda Kanyangela. It's under oath. We assume it's their document. They give it to us. At the beginning here, he says, oh, no, who I am authorized under Section 1 of the ACC. I'm the lead investigator in the criminal case dockets CR 47802 of 2020 of the allegations of corrupt practices as set out in this affidavit. He proceeds on at page 70 to then start talking about racketeering. These are the cases he's investigated, racketeering. Remember, he's an ACC officer, has no powers under POCA. They obtain the evidence. These are the issues that are delaying the case, because if we deal with them at pre-trial, we sort the issue out. They have the effect of quashing the charges. So then I refer you to the affidavit. Then there's the warrant of arrest, but then I want to refer you to the affidavit of Mr. Lutubezi and Mr. Marondeze's boss, none other than Martha Olivia Ekanjo Imarwa. She says that at page 99, I am the applicant in the main proceedings of the POCA restraint. At the bottom, relying on Kanyangela, my affidavit is to provide this court with a status report on the extradition of those Icelanders. At paragraph 12 on page 101, she says, the criminal court ordered the joinder of case 06 and 07, 2021, this case. It refers to the judgment of S versus Gustavo. And then says the extradition must be accompanied by the indictment. Once the indictment has been transmitted, it cannot thereafter be amended. It must be together. Then she's getting rule-compliant evidence at page 105. She talks about how she gets, which means I'm trying to show you here that the investigation is actually being conducted now. We have looked at all, and we just say, this is a summons, look at the date. After the date of our arrest, 90% of the summons were issued after our arrest. 4 years, 7 months, 29 days, hours continuing. And you just automatically just remand them to custody. On untruths, evidence they know that cannot even be admitted in court.
The point that
the point is they are delaying the trial because...
Sorry. You are dealing with the point that it is not you who is causing delay.
Correct.
Rather, it is the state.
Correct, Judge. And on that point, the last point I want to make is that their own counsel, in the Basson case, that counsel, Mr. Vimtrengov, the same very Mr. Vimtrengov was here in Windhoek. We're honored to have him here. He said, and that is the record reflected in SETS, I think 7. No, 6. No, my apologies. My apologies, Judge. Let me just...
About who carries on a legitimate investigation under Section 83.
Yes.
82.
Yes.
Yeah, I read that about Trenkov.
Yes. And that concession, therefore, means that he acknowledges what Section that section, what you call it, 83, was amended. Well, he says, section, if that is the case, then this investigation is wrong. I've showed you. Shanghala is the one who investigated those charges, racketeering, everything. They are the same charges I am facing. Then in 2023, an interesting thing happens. The legislature goes and changes and inserts the ACC in section 83 to empower them to investigate what they never had. So I believe that fruits of a poison tree is a principle that is applicable in Namibia as recently as the Swart Boy case in the Supreme Court, or is it the High Court? Fruits of a poison tree cannot bear fruits which are not poisonous. So if evidence was unlawfully obtained, what is the purpose of dragging us into a trial for 16 years? I believe it will take long, 300 witnesses and whatever. And without dealing with the issues. If we dealt with those issues, when we get to that evidence, you don't need to discuss the issue of the evidence that has been dealt with. And that's not the only issue. When they say they obtained evidence from Iceland, there is no extradition agreement between Namibia and Iceland, no cooperation with Iceland.
Mr. Shanghala.
Yes, sir.
We discussed that a little before. If evidence obtained illegally,
my apologies, Judge.
If evidence obtained illegally is adduced, your position is that it's inadmissible, isn't it?
Yes.
And you are saying it's only appropriate to deal with that pre-trial.
No, I did not say it's only appropriate to deal with it pre-trial. No, that's not what I said. Not at all. Let me make clear what I said. I say it is not only appropriate to deal with the issues of admissibility of evidence after plea and a trial, particularly when dealing with it pre-trial has the capacity of quashing the charges that favors my rights as a person who spent 4 years, 7 months, 29 days, and counting on the basis of lies, misrepresentations made by a body that should actually protect my rights. That is what I'm saying. So if the questions of law are determined, we go back to pre-trial. We bring those motions. Hence, one of the questions is, can the judge really just say because there's a cloud, or I'll just deal with these things then? That is the issue.
All right, let me ask you. One of the points of law you raise is in relation to the judge's appointment. Correct?
Yes, Judge, that is true.
If the appointment is invalid,
Yes, Judge.
assuming the court were to find that it was invalid,
Yes.
you are saying this judge must still continue to deal with the matter.
What will happen if the question is reserved and it's determined by the Supreme Court? Then that is where Section 118 comes in. Another judge takes over those
No, I'm
proceedings.
not talking about the consequence. I'm talking about what happens in the meantime.
Well, in the meantime, the judge must determine whether he reserves the questions, states them, specifically
Now,
records them.
assuming the judge reserved the question,
Yes.
should he deal with any other issues concerning this matter? And
Well-
then it is found that his appointment is invalid.
Judge, I believe that, and that's one of the questions, to continue, will it not further impinge upon the rights of accused who are entitled to an impartial, independent, impartial, and competent court? Because the likelihood of the court being incompetent in the terms of its appointment remains looming. And I suppose now this is the time to bring back the proverbial cloud to say, if that matter, that question of law is reserved, and that is why the requirements are important. Once it's at the trial, it is a question of law, not of fact. It is stated, it's predicated on facts which are obvious on the record. Then the discretion of the judge is very minimal. Recorded, stated, transmit it. In the meantime, we...
No, one of your questions to the Supreme Court, one of them we want reserved to the Supreme Court,
Yeah.
is whether a judge under a cloud is correct to refuse to deal with the matter, with matters pending the determination of the recusal application, correct?
Yes. For instance, such
Right,
as...
just a minute.
Yeah.
In this case, I am postulating a situation exactly like that, where you are challenging the judge's appointment. But you are saying the judge must continue to, even though, in your view, the judge's appointment is likely to be found to be invalid, isn't it? In the meantime, he can do certain things.
It's a question. It's not a proposition. It's a question. So the question requires an answer. I'm incapable of answering it. As an academic...
No, but you have asked the earlier question, is it number 1 or 2? One of the questions is whether a judge who is awaiting a determination of his recusal decision should do things or not.
These are questions.
Huh?
They are serious questions of law in our jurisdictions which have not been determined. I couldn't find, at least and I accept
All
that.
right, I don't think you follow my question.
No, I do. I do. What I'm saying is, I am merely posing the question. I accept that there may be literature and there may be answers to it. I don't have them. If the court finds that there's an answer to this, we don't need to reserve this question. That is fine and well. I'll be educated and edified by it. But I think that there are no questions provided in our jurisprudence on these issues, whether in this specific case or in general. And hence, the point we made previously about developing the law is exactly to the point I'm going at. And it would be very interesting to find out, for instance, whether or not in those circumstances, the judge would then request that this case be allocated to somebody else for case management, or those are all issues that remain to be clarified by either the rule maker or the Supreme Court in advancing common law.
Shall we make progress now?
Yes.
In respect of the state's answer, paragraph 5, you've addressed that.
I have addressed those issues. Now I want to sum up what I've told you. I've told you that...
No. I've heard you.
Excuse me, Judge?
I've heard you.
Oh, you okay.
Yes.
Thank you, Judge.
Now, the other point I would want, because I think that perhaps we will call upon the state to deal with this initial point.
The point in limine.
Sorry?
The points in limine.
The points in limine, I'm more particularly concerned with what they say in their paragraph 5.
Oh, yes.
They can address the points in limine as well.
Yes.
Because, as you correctly observe, the state did not deal with your application paragraph by paragraph. They were content to say this application is premature, dismiss it.
Yes.
Yes. So I intend to deal with that.
Yes.
For the state to respond to that first. Now, but before I do that, let's just go to section 319. I just want you to be clear. I know you've made certain submissions with respect thereto. Section 319.
Let me locate my act. Section 319.
Yes.
Should be there. I am.
All right, section 319. Can you just read where it begins, the first 3 lines or so?
If any question of law arises on the trial in a superior court of any person for any offense, that court may of its own motion...
Yes, you may stop. We have dealt with on the trial, isn't it?
Yes.
That we've dealt with.
Yes.
You believe that must be interpreted to mean even during, isn't it?
Yes. I believe that pre-trial, plea-taking, and trial is...
I got your point.
Yeah.
Now, the next point is, they say the court may what? The
of
court
its
may,
own motion?
What does the word may connote?
It connotes a discretion.
Is it a discretion or simply whether the court may grant that application or not?
It may or it may not.
In other words, the court can decide that these questions of law cannot be reserved.
Yes, and my submission is that it can only do that if the question of law falls out of the bounds of the following issues. One, it didn't arise on the trial or at the trial. Two, it is not a question of law. It's a question of fact which is guised as a question of law. And I've given you some cases on that. Three, that the facts upon which that is predicated are not clearly recorded in the record. And four...
the only point I wanted us to deal with at this juncture is whether the court may refuse to reserve questions.
It may.
It may refuse.
But it is a discretion that must be exercised judiciously. By that I mean in compliance with the criteria that common law has developed. They're not prescriptive. Maybe there's another one. I'm sure that the court has inherent power on that. And I've listed them for you. So in essence, what I'm saying is the discretion is discretion, but once you've ticked off those four, the discretion becomes limited. So for example, Judge, the point that in your interaction with Mr. Mbangasi Omunji, he was making the point that you cannot, for instance, refuse to reserve and state the question of law before you've actually heard the question of law motivated and stuff like that. That is one of the issues I think confine the main.
You know the position I've taken in regard to
the discretion.
To issues that come before me.
Yeah.
I've tried very hard to ensure that we don't have indications, intimations about things.
Yeah.
If one wants to make an application, you make an application and we deal with it.
Yeah.
That is the point I've made.
Yeah.
And you can say, I wish this to happen. That's not good enough to get a ruling from me. I wish to make this application. Make the application and we deal with it. So anyway, the whole point I was asking about
the may.
The may was to simply say there can be grounds upon which a court may refuse to reserve questions for consideration by the Supreme Court.
Yes. I've given you some cases where, for example, it's actually a question of fact, but guised as a question of law.
Or the facts giving rise to that reservation are not clear.
Yes. But the court then says, in Basson as well, says that sometimes it may be itself a question of law. The fact that the judge, for example, made a determination. It depends on the facts. It seems to me that Basson seems to open it up again.
All right. So if you have is there anything else you wish to say? Because I would want to call the state on this, on what I would say is their main defense.
Yes, Judge, I was hoping that the judge would indulge me in a health break to run to the facilities so that I may empty my bladder.
What is the time? Well, whatever you go there to, it's not very relevant to advise us. Yes. But we can take a short break.
Yes.
What is the time now? 1:45. Do you think we need more time than because we can take a 10-minute break come back and continue until we hear the state.
And then,
In which case, you are just shaking your head, Mr. Marondez. What do you mean?
I had
I'm
made a
talking.
request, Judge.
I was just conversing with him, my lord. I was just conversing with him, my lord. I'll take my feet when the court is seeking.
Yes, all I'm trying to assess is whether, on this point, I don't know how much time you need yourself, because his position is, look, the state didn't deal with the rest of the affirmance. The state's position is, this is premature, dismiss it, isn't it? Am I correct?
My lord, the state will argue its case at the appropriate time, my lord.
Yeah, but what I'm trying to propose is Shanghala finish all his submissions and then you respond. Another is to, depending on how you perceive your case to be, another is to narrow down to your point, to your paragraph 5. Because as I asked Mr. Shanghala earlier, if paragraph 5 succeeds, then the whole application falls away, isn't it?
Yes, my lord.
So which one do you prefer?
My lord, the applicant is known for complaining. So the appropriate thing is to allow him to finish his arguments, then the state will respond. Because we don't want to be brought again back with another application that I was not given time to address this honorable court. Then we are faced with another application again.
No. I was not going to do that. I was simply saying, dealing with your paragraph 5 first, and then we can allow him to deal with the rest. But it seems to me you want him to finish all his submissions.
That's correct, ma'am.
And as I said to him, which point he seems to have understood is, look, you have filed submissions, you have filed your papers, you have filed written submissions, which you stand by. You have invited him to highlight certain issues, which we will continue to do. But anyway, since my question is, do we adjourn or...
my lord, we have sat since morning and we have not had an adjournment and we're approaching lunch hour. The state is applying that the matter adjourns now. We continue at 2:15 for continuation of arguments.
Yeah, okay. Mr. Shanghala, you want a break. I don't want to delay you. I never know what might happen. The proposal is against what I thought we should do. Here is the proposal that we adjourn to 2 o'clock.
No problems with that, Judge. I'm amenable, if it pleases the court.
Yeah. Okay, we will adjourn to 2:30. To 2:15. Please be on time. Court adjourns. Mr. Shanghala. Mr. Shanghala, I called on you.
My apologies, Judge. My apologies.
Yes, you can proceed.
Oh, no, Judge, I was under the impression that we were going to let Mr. Marondeze his 2 minutes based on his thin submissions so that I can hear if he has anything to add, which is hopefully nothing, and then I can close it off with my response.
No, he proposed that you finish off, then he will deal with everything at once.
His proposal is not acceptable to me because in the order of things, it is the applicant who hears the answer and then replies. What he's trying to do, Judge, is he's trying to sneak in things he hasn't said in his affidavits so that I have no opportunity to respond and remind him of that. I can do that, but then I can promise you, Judge, I will be of nuisance to you because I will be objecting every other time he attempts to do what I know he will do. Because I've told you, I've given you an indicia of the type of people we are dealing with. And I've also given you what Justice Moses Chinhengo in Botswana has said about the conduct of prosecutors. I don't want to read it into the record, but I must if I will, if you want me to. And I hope that the words of Justice Moses Chinhengo in Botswana carry over to Moses Chinhengo in Namibia. That is the issue. He is trying trickery. I think let's just stick to how it is. It's an application. He must now stand and fall by his papers, period.
We haven't come to him yet. We are still with you, Mr. Shanghala. Can you finish off with your application? Maybe, Judge, since you indulge me, I can round off 1 or 2 issues. Yes.
You recall, Judge, that you and I were trying to define and describe the issue of the may, the word may, in section 319. I think that may, upon proper reflection and assistance by my prison lawyer friends here, is that may relates to who can raise a question of law. It is the court, mero motu, or it is the state, or it is an accused. Then it would also mean that has a meaning relating to what it can do. Once it has raised it itself, it obviously states it, records it, etc. But if it comes from an accused or the state, the court then considers whether it is a question of law. It is based on facts which are properly recorded and reflected in the record. And then, etc., as Magidela and the rest of the cases that I've given you have indicated. And then, at that point, the issue of whether or not the court has a discretion disappears. I haven't found a case specifically on the issue. Then I want to round off the issue, 2 more issues. One issue relates to the authority of Mr. Cliff Kuzulwandle Lutubezi, who has suddenly made an appearance. We thank him for joining us. Mr. Lutubezi ought to have, on his answering affidavit, attached the authority. It is not on the papers. He stands and falls by that. He failed, and the case I wanted to refer you is a Shelf Cove case that relates to, it's relating to how, before Justice Stradom, then as Chief Justice, a case was brought and somebody brought 4 or 5 pages similar to this case, and the court says, and I've quoted it in both the heads and the affidavit, replying affidavit, that then that's it. They're barred by that. Then I want to relate to the issue where we began. How did I get here? When I look at the rules, I've tried to look at them. They don't define for me what an interlocutory is. But I say this is an interlocutory. It arises at a criminal trial. I say criminal trial in which these proceedings, and by the way, the definition of proceedings can be found in a case of Justice Mohammed in Mlungu, State versus Mlungu, very, very elaborate. I think it's 100-odd pages. But here's the thing. If you go to Rule 32, it tells you what the judge may do when interlocutory matters arise. This is an interlocutory matter. I don't base my power to bring this matter, the authority to bring this matter, on 32. I base it on Section 319. It empowers me to bring this issue. But the rules are silent as to the how. And this point I can't stress enough. The rules only provide in Rule 114 a chapter specifically just for this, for criminal trials. Any other thing is outside the scope of those rules. If we were to be pedantic and exercise the type of extreme loyalty, to the text, which Antonin Scalia and that school of thought would want, then it creates an absurdity. It would have to be interpreted.
Yeah, Mr. Shanghala, I've let you go on about what we dealt with in the afternoon.
That's the last point.
Yeah, the idea is not to repeat all over. I think I'm good enough to understand the points you make.
Wonderful. Then, Judge, I would like to rest and hear what the state is going to say. Then I can reply if I'm granted the right to reply.
You are happy with standing by your submissions in relation to the substance of the application?
Indeed, both the founding, as in the notice of motion, and the replying affidavit and the heads, I'm happy.
All right.
Thank you, Judge.
Perhaps I'll hear from the state, but I thought I might have a few questions for you.
Okay.
Are you able to quickly outline the facts on which each of the questions is based?
With pleasure.
And also, in the same breath, try and alert me to issues that were either partly or wholly dealt with in the recusal application.
Okay. Matters which were either partly or wholly determined in the recusal application.
Yeah.
All right. Question 1, can a judge in a criminal matter who is faced with a recusal application, leave to appeal, a recusal ruling, or a petition to the Supreme Court to hear a recusal, refuse to take any further action ancillary to the criminal case in which the judge is being asked to recuse himself or herself, and can such a judge refuse to exercise judicial authority ad interim, other than case managing the criminal matter, or does the recusal application leave to appeal, or a recusal ruling or a petition to the Supreme Court to hear a recusal impair his or her judicial authority to take action or make ancillary orders to the criminal case?
Is that one question or several questions?
This is question 1, which has subsets of questions integral in it. In other words, they are composite. So it asks, can a judge who is faced with a recusal be a judge with no powers to manage a case other than managing a case? Is therefore stripped of powers? He's not allowed to do any other thing other than managing a case by saying, okay, I'm postponing this case to when I can't do anything because there's a cloud. The facts appear from what I hope will appear, let me say will appear, from the record of these proceedings, not these proceedings of today, but previous proceedings in which you've presided, Judge, wherein whenever there was a matter, you've referred to the cloud. And that cloud, if we deconstruct what it is, it is the recusal application, it is the leave to appeal, the recusal application, etc. Does that make the judge incapable of exercising his or her judicial functions? In this particular case, those are the facts. Question 2. Can a judge who is faced...
Just before you go on. Is it first with a recusal application? Is it based on first with the recusal application or leave to appeal?
It is either or, any of those, because I had anticipated that either the recusal is determined or it's determined not to the favor of the applicant, and then there would be a leave, or if there was a leave and it's turned down, there would be a petition, and as it turns out, it has been turned down. But during that period, in this case, was it proper? Because it hinges on, if the judge was not so minded to believe that the judge was, in a lack of another word, impotent in his or her judicial powers, could the judge not have taken action and given relief in some of the issues that were raised by the applicant in this matter? One such issue was release under Section 61 of the CPA. Don't detain me further. And I've explained to you now why you should actually consider not continuing to detain me, because there's just untruths on top of untruths on top of untruths.
Now, was this covered or not covered in the recusal judgment?
This question? No. What was covered in the recusal judgment is that if it is found by the court that here's the petition or the leave to appeal that is granted, that the judge ought to have recused him or herself, then it puts in jeopardy the determinations made. It does not say that each and every determination, and you will recall, Judge, that you and I had a discussion about this. What we discussed was the following. Would it mean
let's just go by the judgment. I'm concerned not what we discussed outside the judgment. Yes. I'm saying, was it covered by the judgment whether a judge facing a recusal application would go ahead and decide other matters connected with the same matter in which his recusal is sought?
Yeah, I understand the question very well, Judge. And the point I simply make on the issue is that the way in which the court dealt with that issue is to restate the law as we understand it from the case law, which is that if it is found that the judge ought to have recused him or herself, then it puts into jeopardy what determinations were made. And the question this asks specifically is, which is not answered in the case law that I am aware of, is does that mean in total that the judge is impotent to take any action in relation to a matter, including now, can he only do case management? That is the question. That question, I believe, has not yet been determined authoritatively or clearly as yet in this jurisdiction.
I don't remember everything I said in the judgment, but I recall I saying I don't have as sharp a memory as you in respect of what I said in the judgment. But I recall referring to some cases or to some case to the effect that whatever you do when you should have recused yourself is for nothing.
Yes, and the question, this question asks is specifically, does it mean that everything in total? Because in those cases that you refer to, there is a specific issue which triggers that recusal application, as in this case. But there are other issues, other things that the court has done. Let me give an example. This court, you have permitted us to utilize computers and an internet. Does it mean that if it is found that this court was incompetent, not properly appointed, I'm just using an example, would it mean that that very order also falls aside? Would it then also not mean that every remand judgment or order you've made falls aside? And those are the questions I'm asking. And if you may recall, we said, and we discussed, I thought we had agreed, that that would be an absurdity. But what are the bounds and limits of that impotence, that cloud, if I were to use the euphemism, puts on a judicial officer in such a situation? Recusal, leave to appeal recusal, or petition to recusal? That's the crux of that issue. And the facts arise wholly from this record.
So your position with respect to the recusal application is that it didn't deal with this?
No, it dealt with it, but not to the extent that this question asks.
To what extent did it deal with it?
It says, generally, and I'll try and find the paragraph when Mr. Marondeza replies so that I can give you the exact paragraph. It basically refers to the cases and says that if it is found that a judge should and ought to have recused himself, then that taints whatever the judge did. The question is, everything in total?
Even if it is answered positively, what does it matter?
Well, then, if it says yes, in total, then it means that I cannot have the relief, I cannot be heard to say, I was denied relief because the judge had misconceived the handicap that existed because of the leave to appeal the recusal itself and the petition.
So what matters came before me, which in your view should have been dealt with despite the recusal application?
I asked you to release me.
Sorry?
I asked you to release me from detention.
Did you make an application?
Am I obliged to make a written application, or can I not make it from standing here? And you recall when we discussed it, and I asked you, how do you understand an application? Is it something that is written down, or can it not be made from the bar, for example, or from standing here, from the dock?
And what was my response?
No, you said you can make it standing from here, and I've done it on diverse occasions, today included.
Well, whether that is a fact uncontestable, I will decide.
Question 2, if it pleases the judge, I want to move to question 2. Can a judge who is faced with a request made pursuant to Section 319 of the Criminal Procedure Act 1977, Act 51 of 1977, defer, hold in abeyance, or refuse to consider such request, and exercise the discretion to reserve, state, record in the record, and transmit to the Registrar of the Supreme Court the request when it is made? These facts, again, are apparent from the record. This is the third attempt. If I want to be technical and pedantic, it's the fourth. The first attempt, I gave you something in writing. You said, no, I will not consider this until we have done the pleas. I stood up, you repeated it again. And then in your judgment, you made the remark I read to you at paragraph 24. Then I brought an application ex parte. I filed it there, but I also brought one here in court to say that if it shouldn't be in the motion court, I brought one here now to put before you. And the position I understand the court to hold, hitherto, is that the court holds everything in abeyance until whatever has happened, whether it's the plea or whether it's the cloud. My question now here is that proper? Can that be so? Shouldn't it be that once a Section 319 is made, an application for questions to be reserved, stated, specifically recorded, and transmitted to the Registrar of the Supreme Court, when that is made, and it's not a factual question, and it is the facts are evident from the record, etc.
The factual question is whether it was done.
What I'm saying,
whether it was either intimated, notified, or actually done as an application. As I thought, which you don't agree with me, an application utilizing Section 317, subsection 2 onwards.
Well, my point is, and this is the point that Mr. CEO Munji exchanged with you on, is that you couldn't have reached that point to exercise the discretion unless you've heard the question of law put to the court.
Well, we can't go over the same
Yes.
thing. I have said in these proceedings, if you have an application to make, unless it's such a very minor application, because the kind of difficulties that we tend to face as to whether this was done or that was done. That's why I said I would prefer a formal application. A formal application, and I deal with a proper application placed before me. Not an intimation, not an indication that I want to do this. Not an observation, for instance, that or intimation notice that, you should do, admit me to bail. You see, that kind of thing. I've said I would rather, for neatness' sake, have everything properly and formally met. Right, you can proceed. You're on question number 2. You have done question number 2, isn't it?
Maybe, Judge, may I just request that maybe to avoid this type of area, the gray area, if I may call it, a gray area where we don't know really what was said, and as you said, the memory is not as sharp. I must say I've got jailitis or whatever from jail. I'm also forgetful. Is it not perhaps possible that we may have a standing order that if we require the record, that your office can issue a request urgently so that we get it from the transcribers? Because I had requested, I understand that they may be inundated with work, but I just hadn't received. This would not be a discussion. But watching the video last night, I saw the judge clearly stop me from speaking, but I'm looking forward now, if that can help us move forward. This is paragraph 70 of your judgment. I'm being referred to by my...
I didn't object. You talked about...
No, this is paragraph 70.
Yeah, but I didn't say your point was wrong, did I?
Okay.
Or it was not sufficiently supported.
Okay. Because here it talks of your refusal.
All right, you can read it for what it is worth.
Okay, all right. Thank you. It's paragraph 70 of the judgment. I then move on to question 3, if it pleases the court. Question 3.
I hope you bear in mind that the issue you are dealing with is whether there are enough facts.
Yes.
Upon which, uncontested facts upon which these questions are to be referred.
Judge, in all the cases that I've read and I've given you, the qualifier of uncontested is not there.
Whatever, but using what you understand the cases to be, you can use that standard.
Yes, because that introduces an element that is different. The very point I make
because
is...
the cases talk about clear facts, isn't it?
Yes, clear.
Yep.
It may be clear and contested, but it is there. And I am simply saying this, that regrettably, I don't have the record, but the record will have, because I've seen the videos, I've relied on the videos, that, and we're doing our own recording, and NBC is doing the recording, we pick up from there. I know it's not the authentic record, but it is in the record. That is the point I'm making. Those facts for those questions are in the record.
Right, you may proceed.
Does the lack of legal representation of the above-mentioned applicants in the criminal case number 06-2021 not amount to a violation, infringement, impairment, and negation of their fundamental right to a fair trial under Article 12 of the Namibian Constitution, and will the continued prosecution of them until the matter of their legal representation is resolved as outlined in the case of Luboya versus the state, case number SA 27-2003, SC 2007, not amount to such violation, infringement, impairment, and negation of the right to a fair trial? Two things need to be said
The
here.
only question I have in respect of that, was it canvassed and covered in the recusal judgment or not?
Judge, if you give me a moment, I'll ask my legal assistants here from prison to check if Luboya was covered. But what I can say about it is that I handed Luboya over to the court.
No, I'm
This is-
talking not about Luboya, I'm talking about the issue you raised.
The
here.
December 5, 2023 address is covered in the judgment.
No, the issue about legal representation in the absence of proceeding with the plea or with the trial in the absence of legal representation, was it or was it not covered?
It was. It's in the judgment. The Section 319 does not contain a disqualifier that if the judge has dealt with it somewhere, it can't be raised as a question of law. The question of law and whether it is good or bad inherently is not for this court. It is for the court to which the question is being made.
Yeah, but the reason I'm asking this, if you could be patient with me, is this: if the Supreme Court answered it,
The Supreme Court.
yes, if the Supreme Court answered it, would it be proper to put the same question to them?
Well, Judge, I have this to say to that question. Mr. Marondeze, and I'm not so sure if you had agreed with him, fully or partially, but there was some form of a consensus, was that surely this trial will start at some point, with or without representation, this case, and then on December 5, I gave the euphemism of a Deutsche Bahn, if you remember, that it's just rolling like the Deutsche Bahn. And I say that is wrong. Now, that a prosecutor of seniority of Mr. Marondeze and a judge of your caliber can hold the view, and I qualify pro tanto.
No, I think you are going outside my question. My question is simply this: if this issue was canvassed in the recusal application and the Supreme Court endorsed the recusal application with what it contained, is it not putting the same question back to the Supreme Court?
It may very well be that, and I've asked myself that question, and I've answered myself to say, is there any prejudice being occasioned by that? Is it not going to enhance the protection of my fundamental rights?
Before we make further submit, my question was it covered or not by the recusal application? Because your further argument is, even if it was covered, there would be no prejudice, there would be nothing bad about sending it back to the Supreme Court, isn't it?
Yes. What
All I'm saying is, can you deal with the first question first? Was it or was it not covered in the recusal application?
May I request the judge to give me a moment? Let me move on with the rest. When Mr. Marondeze is done with addressing, I will particularly answer that question. I'd like to reflect on it.
All right, but it is a question that applies to not only that question, and I said that in the beginning, that in your address on the facts, please try to deal with the question whether this was dealt with in the previous judgments or not.
Okay. That is clear, Judge. I'll revert to that issue. Then, okay. Then I move to question 4. Does it not amount to a violation of the right to a fair trial and prejudice to the accused persons that pleas had been taken for some of the charges and counts in December 2023, yet the state made disclosure of some 30 files on 15 February 2024 of material information that was not previously disclosed, which, if such were disclosed before the taking of pleas, could have been the basis upon which accused could bring certain applications to court, or to enter pleas with plea statements, or to enter any of the other pleas under Section 106, besides the plea of not guilty entered by the court in terms of Section 109 of the CPA on their behalf, and will it not amount to a further violation of the right to a fair trial and prejudice to continue with the taking of pleas whilst accused persons have not had the time to adequately consider the new disclosure and to take advice from counsel on it before entering their pleas? I want to say from the get-go that I don't recall this being covered in the recusal at all. One, I want to recall it as a fact that I have put it to the court, and the court refused to accept those papers at the time when I made the disclosure to the court that disclosure was made by the state on the 15th of February 2024. That would be reflected in the record. It doesn't matter anyway because those issues are now before the court as evidence attached to an affidavit before this very court. And the question is this. Pleas have been taken. Evidence is divulged after the pleas are taken. Evidence which actually ought to have been disclosed day one, the real evidence actually, where this case commences, out of which many irregularities come.
Sorry, can I just ask a side question there?
Yes, Judge.
When the state produced this, we call it a pre-trial memorandum.
Yes.
What was the response?
When the pre-trial memoranda was done, there are two: status report and a pre-trial memoranda. The first one, Mr. Marondeze, with the flippancy he's used to, says,
what did any party say that they want to respond to the state's pre-trial memorandum or not?
We have indicated that we will not be answering the questions in the pre-trial memorandum. What we have done instead is asked questions in a status report and a pre-trial memoranda of our own. Because when we first raised the status report, the prosecution says...
It may be necessary for me to look at the status reports you're talking about. These are status report of when and when?
I will give you the dates, Judge. In fact, I have the hard copies here. The first one is dated the first one is dated 15 September 2023. That was the status report. The state objected to it being called the status report. They said, yeah, these are terminologies from the civil stream, etc., etc. Then in the second one, that terminology was dropped and it was termed...
Is it that first status report, what happened?
Well, you recall, Judge, nothing happened. That's what Mr. Murora was saying, the indifference. That's what Mr. Murora was saying, there's just indifference. We've raised these issues, we've written letters, indifference.
No, what I'm saying in respect of how
the
was
status
it?
report raises a number of issues,
Yes,
Judge.
how was it dealt with?
It fell on deaf ears.
Whose deaf ears?
Those to whom, in fact, let me explain to you, Judge. After that one and the second one, a meeting was held, sorry, my apologies. A meeting was held with the registrar. And issues were raised. The registrar responded to her issues. For example, the courtroom, a consultation room, etc., things that I want us to address later. The state was asked to disclose certain things. The state then brought that disclosure on 15 February. Okay? The other issues, they, for example, say, no, we're not going to give you this. But when they say that, for example, we asked Part A, Part B, Part C of the investigation docket, the diary. As I showed you today in the document, that Nelius Becker document, that is Part C. So we want all of Part C. So I don't know what the opposition is. But then we came back with another one on 12 October 2023. This time we dropped the nomenclature. We called it accused persons 2, 3, and 6 practice direction 45B pretrial memorandum. Then we raised a number of issues. They remain outstanding. I can take one issue. Where is the Section 31 of the ACC Act referral? Yes.
You don't have to go into
remember,
detail.
Judge, they've been handed up to you before, so you should have them. But if you don't have, I'm happy to make the copies straight away.
We should have them.
Yes. Then, on that basis, we were saying, let us not move out of this pre-trial. Then Mr. Murora said, look, we're still trying to get paid, find the money, whatever.
All right,
Those are the facts.
Can you assist me? If you answered the state's pre-trial memorandum, would those issues have been raised?
If I had answered them, sorry, my apologies, Judge. My mouth is dry. I just trying to. Sincere apologies. Would the judge kindly indulge me with repeating the question, please?
The question was, would the issues which you are raising in your pre-trial memorandums have been answered that you responded to the state's pre-trial memorandum?
I didn't get the last part. Let me move on.
The state filed a pre-trial memorandum, isn't it?
Indeed.
A lengthy one.
Indeed.
My question is, had you responded to that? You said you declined to do it, isn't it?
Yes.
Had you responded to that, would some of these issues have been covered?
Oh, I see. Let me answer your question, Judge. I'll give you a short and a long answer. No. That's the short one. The long answer is this. The state has embarked on a fishing expedition in the pre-trial memoranda. Confirm this, confirm that, confirm this, confirm that. What we ask in our pre-trial memoranda is totally different. Do you intend to use this evidence, this unlawfully obtained evidence, etc., etc.? And then the attitude that the state prosecutors take is we'll not be engaged, we're not going to get into this at all. They didn't record that. Our erstwhile lawyers tell us that this is the response they get when they go and visit the lovely chambers of Mr. Kuzulwandle and Mr. Edios Marondetse. So we have, and by the way, Judge, it is my right not to answer questions, to remain silent. I have no duty to prove myself innocent. It is the state that must prove its case. The pretrial memoranda of the state is not mandatory at all, as far as I understand the law. I could be wrong. Again, prisonitis could be affecting me. But if the court were to compel me to do so, the attitude I would take is that I have a right to remain silent. I do not have to prove myself innocent and answer the incriminating questions that they do want me to state, to answer. And no, answering them would have not sorted out the issues that we raised in the pretrial memoranda. And as the court said, once the court reads it, maybe the court will understand. You see, Judge, for instance, one of the issues we are asking is, how is it possible that a journalist from Al Jazeera can have my bank accounts and that of the late president? How? I'm in Morocco, I'm being interviewed, and these bank accounts are there. As you sit there, Judge, I don't have access to your bank accounts. Only you, your banker, your central banker, an investigating officer, or somebody who you've given the bank accounts. I'm sitting in Morocco, and the guy is saying, actually,
right.
I've got his affidavit here.
Yes, Mr. Shanghala. One of the issues in the recusal application was that it was wrong to proceed with plea taking, isn't it?
One of the, sorry. Judge,
One of the issues
yes, sir.
in the recusal application
Yes, Judge.
was that it was wrong of the judge to proceed with plea taking.
In the recusal. Yes,
It was one of the issues.
yes.
And it was answered, wasn't it?
In the context that it was raised by the applicant, yes, it was answered. My questions are different. They hinge on different aspects of that fact that the pleas were taken. Pleas were taken, not in doubt. It was raised in a different context. This is a different context. This is a context about fair trial, a context about whether or not the judge's position in moving out of pre-trial, etc., etc. These questions are, with respect, questions of law, procedural, but substantive as well, insofar as they relate, for example, to fair trial, etc. For example, this very question 4. You see, how do I, now that I've played, okay, here's another issue. I thought perhaps one of the issues that were being dealt with in the recusal was Nigel van Wyk, accused 10, has an application pending before another court. I've given you a court order there by the court judge, Justice Rakau, where she's faced with an issue and says to the parties, wait, this issue is being determined elsewhere. Let me have that issue being determined. It's a review of the charges. Now, we thought maybe the judge in this case would do the same in terms of that application of Mr. van Wyk accused 10, that it would say, okay, the bolter one is being decided.
We know there is a judgment on that, isn't it?
No. There's a court order saying.
No, I'm talking about my judgment.
Yes, that judgment is existing.
It's
extant.
there, isn't it?
It's extant.
Yes. So that judgment dealt with that issue, isn't it?
Yes, but what we are saying, Judge, that the context that relies on that very issue which you dealt with is a different aspect. Okay. It's like coming into this court. We are all in this court. But I come in here as an accused. You come here as a judge. We are both in the court. We didn't come in the same way.
All right. If you have nothing else on question 4, question 5.
And maybe, as I round off, we should just be borne in mind that we're not parties to that application. So, to the extent that I may raise issues,
well, the point also is that when you are served with an application, it's up to you whether you want to say anything or you don't.
Well, silence does not amount to consensus, is my response, my retort to that, Judge.
You mean acquiescence?
And acquiescence, I don't acquiesce. I've actually said that I was denied the right to participate because they didn't serve me. The state didn't serve me. That is the position that the records of this court will reflect.
All right.
Question
number
5.
Mm-hmm.
Is the appointment of Mr. Chinhengo as an acting judge on 27 April 2023 for the period 18 September 2023 to 31 December 2023 not ultra-virus and unconstitutional as articulated in the representation on legal representation made to the Honorable Court on 5 December, there's an errata there that says 4 December, it's 5 December 2023, and whether reliance upon Section 7 of the High Court Act of 1990, Act number 16 of 1990, is not misplaced on account of the supremacy of the Namibian Constitution, which under Article 82.4 explicitly provides for a fixed-term contract of employment for non-Namibian citizens appointed as judges. Judge, you will recall that this was not dealt with in the judgment. To the extent that the judge says there are threatened action, that is perhaps one of the issues that was being threatened. I indicated to the judge, and the record will reflect, that I was taking a lot of matters under advisement. Why? Because we had just experienced an issue where an application was made to join Justice Miller on ostensibly the same facts in a case we intended to bring against the late president. This matter was unopposed, but on the day it was heard, there was a government attorney person apparently on a watching brief. We don't know whether that person was sitting at the bar or just somewhere in the audience, but they were on a watching brief. Somehow, Justice Boas Usiku decides, oh, no. You should have come on an ex parte basis. It's unopposed. Our representative is saying it's unopposed. What harm will it do? We serve them anyway. No. And then the watching brief finds its way into the judgment, and it's thrown out that it was not properly there. So then we appeal to the Supreme Court. That appeal is still pending, and we understand the backlog there. So I was not just threatening. I'm constrained by the fact that I'm in another forum, so to say, and I cannot proceed yet until that determination ostensibly. Now, what these questions of law do is that they bring the same matter before that court, and possibly even expedited. Maybe when the court will see that these matters are similar, maybe I must consider them together or whichever way. But that question is now live. And again, it's not for this court to say there's sound, because the state was making representations, I don't know on behalf of who. Certainly, they can't have been making representations on your behalf, Judge, because we would have heard you ask them to do so. You didn't do so. They were saying that, oh, no. But Mr. Shanghala, former Attorney General, blah, blah, blah. And I said, oh, let me finish the CV for you. And then I referred them to the fact that Section 7 doesn't avail to them. Section 7 is subservient to Article 82.4. Article 82.4, based on Article 1 of the Constitution, which is the supreme law, says that non-Namibian...
Remember, we are not arguing the legality of this or the...
Yes, Judge.
We are not arguing the points.
Correct.
We are simply trying to understand whether this can be reserved for the Supreme Court, isn't it?
Yes, Judge.
I'm not going to decide, because if I were, the first hurdle would be whether I'm not being called upon in a conflicted situation. Now, the point I want you to submit on is, how would the Supreme Court deal with the facts when the matter is placed, or this question is placed before them, without the appointing authority being involved?
The question of law, well, okay, first of all, the Supreme Court can invite us to make representations on that issue. I'm prepared to make representations on that issue. But since this court is not hearing the matter, it doesn't help me doing that. Secondly, the Supreme Court is entitled to receive, because it's the same state, Mr. Marondeze being a prosecutor, Mr. Kuzulwandle being a prosecutor, are subject to the Prosecutor General, whose final responsibility is exercised by the Attorney General, who should at least be the one in court. I would suppose that the prosecutor, he would run to his master, that master would run to the main master, and that master would go to the main master. They take a position. They then approach the court because they are a party of interest. Our law is such that a party of interest can at any stage intervene.
At that stage, they would then be able to put the facts before the Supreme Court.
Yes. Well, this is a legal question. The facts are that there was an appointment.
You see, this is why I'm going back to the clarity of facts. Because if the facts are not clear on the record, then the Supreme Court, if I referred this question to them, they would have to understand exactly what happened in the appointment of Chinhengo, isn't it?
Correct.
They would have to decide facts and then the applicable law. But anyway, I'm raising these questions so that you will because I assume that even if the state is not entitled to say more in relation to the substance, isn't it? Mm-hmm. It's not. It doesn't follow that you will get the order, isn't it?
Yeah.
That's why I'm asking you these questions.
I appreciate the question, Judge. I think it's a very crucial question. It goes really also to the issue of fair trial. It must be given an opportunity to be ventilated on both sides.
Yeah, but the thinking I have is the reference of questions of law to the Supreme Court in the context of Section 319 was not intended for the court to look for facts. That's why they say they must be based on clear facts.
Yes.
The court is not going to be a court of first instance in dealing with the appointment of Chinhengo, gathering the facts, then making a decision. The facts must be so clear and uncontroverted on the record. Then they say, yes, if these are the facts, uncontroverted, we make the position at law is the following.
I make the submission that 3 facts are uncontroverted. 1, there was an appointment done by the president on the date I indicate in the question, and that is on...
Yeah, the facts you state there, you are saying they are taken to be correct.
Yes, because they are based on government gazettes. In terms of Article 32(8), any action done by the president must be notified in the Gazette. It was done on 27.
Just for interest's sake.
Yes, Judge.
Why did you not think that the proper approach would have been to challenge the appointing authorities?
No, that's what I was indicating to you, that I'm having an appeal pending in the Supreme Court about the modus operandi that we utilize, the method. The High Court says we should have come by ex parte application to get permission from the head of the High Court that whether or not we can cite a judge as a party to an application. And in that application, we told the head of the High Court, which is the Deputy Chief Justice, that he has a conflict, he must recuse himself, because in Article 82(3), he's the one who applies to the president for an acting judge to be appointed. Then it was dealt with by Justice Jose Angula, who is then the Deputy Judge President. We followed that instruction. Nonetheless, Justice Boas Usiku comes up with this. We don't know where it's coming from, really. That's why we're sending it to his bosses there, so that he can also be given direction.
I remember you at some point intimating that you were going to sue the president.
Yeah.
You abandoned that course.
That is the action that pursues the president. So once it's determined whether we are right or wrong, we then go ahead. But while it's pending, we couldn't. But nothing stops me from this question of law. And I was at the facts. The fact is, the Government Gazette records, and we must believe the Government Gazette. It says 27 April 2023 to 18 September 2023, on 27 April 2023, Judge Chinhengo was appointed as an acting judge. From when to when? 18 September 2023 to 31 December 2023. That time has come and gone. Then there was another proclamation done in January. Judge Moses Chinhengo is not reflected in there. Another fact. And these are once we've established those facts, the questions of law now come. Can Section 7 avail to the appointing authority to say that, no, because of Section 7, the person continues? And we say that person continues only in respect of the proceedings. Which proceedings? Trial proceedings. And that is why I referred you to Umlungu before the judgment of Chief Justice Mahomet. And he defines there properly also the Zuma case, one of the Zuma cases. Now, if you go into that, you then find out that Section 105 says a trial only commences after pleas have been taken. The trial aspect. So you have pre-trial proceedings, you have plea proceedings, then you have trial proceedings. In there you can have interlocutory proceedings at any stage. Now, my issue is this. at any part of this continuum, which is part of the trial, under the substrata under trial, I may bring a question of law. The facts are, as I've indicated, the legal questions are, one is the Section 7. One is, how would then the definition of, how would then the proviso in 82.4 be applied if the Chief Justice is unable to go beyond that age, but an acting judge can go beyond that age? Thirdly, another issue that arises is, can you, at the age of, say, 60...
Let's not deal with the substance.
Yes.
Of it. There's no point addressing the substance of it here.
So the reason why I was raising is just to say, those are legal issues only. The facts are blatantly obvious from the executive functions that were exercised, and that's the state of mind. If they want to raise it there, if it arises there, is another issue.
You do appreciate that a Section 319 application is not designed to place the Supreme Court in a position where it is to establish the facts itself.
That is why, yes, Judge, I agree with you. I fully agree with you. That is why I'm saying the facts are blatantly obvious from my perspective, from the question itself, and they're based on what the executive function exercised and performed as announced in the Government Gazette. And the absence of anything to the contrary is a fact in itself. And I'm saying that in there the Supreme Court will have to, because that question is at the heart of what we call an impartial, independent, and competent court. That is a right that is not non-negotiable. You cannot negate it, because if I were then tried by a court that is, for instance, not competent, just get, for example, who's the bête noire of human rights in the world? Russia. Gershkovich type of approach, and then you just put somebody there, maybe the qualifications in law are not even, then I wouldn't, that's a kangaroo court. And I do not, I'm entitled to a competent court. And that is an issue that the court has to take into account. This is therefore a question of law that is at the heart of this trial. Then question 6. In the light of what Section 105 of the CPA provides and what Section 7 of the High Court 1990 provides, and given Section 118 of the CPA, regarding the non-availability of judicial officers to continue... Is it not the
same question, really?
It is...
The same question with question number 5.
Similar questions, not the same, but similar.
Would question number 5 not be, when it goes to the Supreme Court, would it not be answered... by their determination of what Section 7 of the...
It would be, it is likely to be, if you answer the other one in a given way...
And then if you answer the question whether Section 7 applies,
yes,
both 5 and 6 are done.
But that fact that the Supreme Court could do that, and now we enter into the realm of conjecture, that is not a disqualifier for the question itself. Again, whether it's good or bad is another...
No, I'm talking of whether that question number 6 is different in substance from question number 5.
I think it is, because what this means is this. 5 says, is this a competent court, yes or no? Then 6 says, would the consequence of that not be that a judicial officer, other person, can then take over the matter? Because the difference is this. If we are in trial and that judge is no longer available, we probably have to start de novo, isn't it? But before the trial starts, and pleas are not the trial proper, you take the pleas before the commencement of the trial. That the words used in the Act, Section 105. Then it would mean that it is permissible that another judge can take over. So it is consequential to the previous one, but not and related, but not the same.
Okay, proceed then.
Question 7, whether the acting judge's order taking, my apology, let me start again. Whether the acting judge's order that the taking of pleas must proceed before him, notwithstanding that the accused persons impugn the constitutionality of his appointment as an acting judge of the High Court, and also some of his decisions, falls to be set aside on the basis that the order is unconstitutional, as it violates the right of the accused under Article 12(1) of the Namibian Constitution to be tried by an independent, impartial, and competent court. This question, Judge, can be looked at two ways.
I'm going to explain the question. The issues I've asked you to deal with, are there enough facts backing up the question? Number 2, was it not covered in the recusal application?
Yeah, I believe that the facts are similar to the facts relating to the issue of the appointment because it hinges on that the appointment is being impugned. Those facts, therefore, would be similar. And that, no, that was not dealt with in the recusal. And that I believe that that is a central question to a fair trial, as I indicate in the question, and that this requires really no other fact other than the arguments in law looking at the thematic propositions which are proposed in Chapter 3 of the Constitution and the CCPR that a fair trial must be before impartial, independent, competent court. So,
if the Supreme Court was aware of the legal point you are raising in 5, 6, and 7, what do you think they would have done? When they considered the petition, what would they have done?
What they would have done or what I seek from them. Those are two different things. The first one, anybody's guess is as good as mine because nowadays the Supreme Court, I don't know, they return people to prison even when it's unprecedented. I don't know, when convicted people are out. So it's a toss-up there. They're now policy makers. They are talking about gays and whatever. I don't know what the Supreme Court will do. But what I would like them to do, I'll tell you what I'd like them to do. I'd like them to say, yes, indeed.
No, my point was simply whether the appointment of Chinhengo was not such a glaring issue, such that they would have taken note of it when they considered the leave to appeal.
Or if they had considered, if the leave to appeal had proceeded. Did I understand the question correctly?
No, the recusal petition. When they considered the recusal petition,
yes,
was the validity or invalidity of Chinhengo's appointment not an issue that would have occurred to them?
We perhaps, if I had sight of the basis for the ruling that turns away, and the way I understand it is that once a petition is denied, it ends there. There's not even need for a ruling, for reasons. If we had that, we could best understand what they're trying to guide us in as the apex court. But I haven't seen one. I don't know, was there a judgment?
I understand there
was,
never is.
Excuse me, Judge?
I understand there never is.
Sorry. There never is a judge. Yes, correct, Judge. And also, I don't know whether or not this particular issue was in the submissions made in the petition to the court so that the court is given an opportunity to reflect on the issue.
Those questions, in substance, are, for lack of a better word, another recusal issue, isn't it? Or an incompetence issue.
The issue of the competent court is different from the recusal, substantially. Because a competent court can also be asked to recuse itself.
And my last question is, do the questions 5, 6, and 7 arise on the trial?
That is the extent to which I've gone to explain why I've given you cases like Tucker, like I think Magidizel, that case, Magidizel, I've given you the cases, and the definition of proceedings, because I couldn't find definitions per se in the Act, the CPA, or the rules per se. So I've tried to look at the case law. And my understanding of on the trial is that the word trial is inclusive of the proceedings in the pre-trial conferences, of the plea-taking proceedings.
So your position is what? Yes, these questions arise on the trial.
Based on my reading and understanding of the law as espoused by Basson and Boekhout, that is my understanding, that these questions arise on the trial.
Yes, anything else? Do you have anything else to say?
No, Judge, I will at this point, I'm eagerly waiting to hear what my friend Kuzulwandle will tell us.
Which one now is qualified?
He's here now. It's the one who wasn't here before.
Which one do you want? Which one is qualified? Right. For the state.
If it please, my Lord, the state has filed a notice of opposition, answering affidavit and heads of arguments. The state will abide by its heads of arguments, but would want to amplify on the following points, my Lord, which have been raised in argument by the applicant. My Lord, I'll deal with the points in limine first on the authority of Mr. Lutubezi to file an answering affidavit. My Lord, the applicant has made a concession that indeed he cannot dispute that Mr. Lutubezi has been duly appointed as a prosecutor and has been appointed to handle this matter, and he has authority to prosecute this matter. He is the prosecutor in this matter.
This matter, you mean which one?
Pardon, my Lord?
You are talking about his concession. When you say this matter, which one are you talking about?
This trial, the main trial.
So let's distinguish, because
the main trial, yes.
Conceded to...
Yes, in the main trial. He considered that he has the authority to prosecute the main trial of this matter. And that concession, my Lord, was rightly made because at one stage he bragged in this court that he was my boss, he was my previous boss, and at the same time it extends to Mr. Lutubezi because he was a prosecutor at the time, he was Attorney General, and at the time he was Minister of Justice. And the status of Mr. Lutubezi has not changed as a prosecutor. He has continued to hold that same rank by the same appointment. When he was the boss, he could not have been a boss of a prosecutor who is not properly appointed. So, my Lord, the point which is there is that today we are not dealing with the issue of the appointment of Mr. Lutubezi or the authority to prosecute the main trial, because the procedure is highlighted in Section 106, Subsection 1H. If they had any queries with the authority of Mr. Lutubezi to prosecute the main trial, they would have raised a special plea in terms of that section I've referred this honorable court to.
No, but they've said they have no problem with that.
Yes. Therefore, if they don't have that problem with that, my Lord, we go now to the next point, my Lord, which is important, is that we should not treat this current application separate from the main trial. Because when he started addressing the court, he told the court that this application emanates from the events which happened in the main trial. Now, if Mr. Lutuvezi has a right to prosecute the main trial, and those events happened which led this application in that main trial, Mr. Lutuvezi has the right to prosecute any matter which arises from the criminal trial in which he has authority to prosecute. That the applicant decided to file an ex parte application is neither here nor there. It remains a criminal matter, my lord. Anything that arises from the criminal matter remains a criminal matter. No matter what label he decides to give it, even if he dances on top of his head, it remains a criminal matter, my lord. I have made reference to this honorable court to the matter of State versus Strovisky.
Is it in your head?
It's not, my lord. It's a point in limine which was raised, my lord, after heads of arguments had been filed.
But you're saying you made reference to this court.
Pardon, my lord?
You are going to make reference now?
Yes, my lord, of that matter.
Okay. What case is that?
It's a reported matter, State versus Strovisky. 1994, Namibia Law Reports, page 265. In that matter, the accused had filed a notice of motion raising constitutional points. And it argued that the provisions of Criminal Procedure Act did not apply. The court made a ruling that it doesn't matter. Anything that arises from a criminal matter remains criminal. No matter whether it's brought under a notice of motion, it remains a criminal matter.
Yes.
This applies to this court, my lord. There's a concession that whatever is this application is concerned is emanates from events which happened in the main trial. So whatever it is, it remains a criminal matter, my lord. And Mr. Lutuvezi has a right to handle whatever issue arises thereof, including myself.
You were not challenged. They didn't know that you...
No, he didn't challenge, but because if he is accepting my right to represent this court, the state in this present applications, the same applies to Mr. Lutuvezi.
Carry on.
My lord, it has been argued that there's not a proper notice of opposition before this honorable court by the state. But, my lord, because he couldn't recognize the signature on the notice of opposition. I'm trying to, from his bundle, to find the notice of opposition, my lord. But he has not challenged the signature on the heads of arguments. But if the court looks at the signature on the notice of opposition and the signature on the heads of arguments, it is the same signature.
He says it's not.
Pardon, my lord?
He says it's not.
But it's the same. That's my signature. It's me who signed the notice of opposition and the heads of arguments. It's my signature, and my authority has not been challenged to do that, my lord.
Oh, I thought you was comparing the signature on the notice of motion and the signature on the answering affidavit.
My Lord, those signatures are just the same, my Lord.
No, the answering affidavit.
No, the answering affidavit. He challenged the signature on the notice of opposition, and that is what he said. He doesn't know that signature. My submission is that signature on the notice of opposition and the signature on the heads of arguments is my signature.
All right, that may be so, but I'm saying his challenge was he raised the point that the signature on the notice of motion is not the same as the signature on the answering affidavit. So he was saying that notice of motion was not filed by Mr. Lutuvesi, who then filed the answering affidavit.
That is correct, my Lord. The signature on the notice of opposition and the answering affidavit are different because the affidavit is for Mr. Lutuvesi and the signature on the notice of opposition is my signature.
But he challenged the signature as unknown. That was his point. We don't even know.
It's mind-boggling, my Lord, because he is not seeing that signature. He was my boss. He even saw it when he was my boss. He is very familiar with my signature. And that is a signature which has been, from the onset of this case, that is a signature which has been appearing, my Lord, on all the documents.
So he should have noticed that, this is Mr. Marondeze.
Yes, he should have known that this is my signature. That is my signature, my Lord. But he was so much blinded by challenging the authority of Mr. Lutuvesi, he could not see that it is my signature. I forgive him for that.
And obviously you are saying, what are you saying? Because his essential point is, whoever filed these notices of opposition, notices answering affidavit, and I suppose he can go even further to the heads of argument. He's saying these people have no authority from the Prosecutor General. There's nothing to show that they are authorized.
My Lord, that's why I referred this honorable court to the matter of State versus Trotsky, and that his main concern that we have authority to enter the main trial, which is from which this application emanates from, and we are entitled. The argument is that we are entitled to handle any other matter which emanates from that trial for which we have authority to prosecute.
So your position is on State versus Provisky?
Yes, ma'am. Okay. This is a criminal matter. This is the same criminal matter. We are entitled to handle anything pertaining to that criminal matter, my Lord. And therefore, we have the authority to argue this matter, my Lord. My Lord, the other point, now we move further, my Lord. I have to move fast because the time is moving. We go to the issue of his interpretation, why these proceedings, he should be allowed to proceed with them, and they cited the matter of State versus Basson in the South African jurisdiction. As correctly put to him by this honorable court, that authority remains persuasive. However, what is most important about that case, my Lord, that case was not to determine when should Section 1319 proceedings be brought. That case was determined whether the state can appeal against the dismissal or the quashing of charges. That was the main concern of the case, and that ruling was made at paragraph 152 of the judgment. That was the basis of why the interpretation of Section 319. I don't need to read paragraph 152 because the court has been given that authority, but it was to determine whether an appeal against the dismissal or quashing of charges can be appealed against by the state.
By way of the 319?
Yes, ma'am. That was the basis of that matter.
And what? And it didn't deal with
It didn't deal with the issue as to when can Section 1319 be brought, and at one stage can it be brought, my Lord. And if you look at the history of Section 319, my Lord, Section 319 was there at the time when the state was not, before this amendment, state could not appeal against the acquittal of an accused. And therefore, but it was only allowed to do it on the point of law. And then the state would be allowed to raise this point of law by virtue of 319. That was historically that's what it was. Then it was amended to the present state. Now, in this jurisdiction, that issue has been determined as to when can that application be made. It's we have cited the cases, the two cases which have been referred to by the applicant, and those cases are authority, my lord, as to when. And when he was being questioned by this honourable court, he could not point to any other case which says to the contrary.
Can you point to any other case yourself?
Pardon, my lord?
Can you point to any other case yourself?
We have those two cases, my lord, which points to the same position. We have no other case which points to the contrary of what we have stated, my lord.
Malum was a High Court case, isn't it?
Yes. And Pinero was also the High Court case, my lord. And those cases have not been appealed against.
Yeah, but his point was they didn't necessarily bind me.
My lord, there is the principle for certainty of the law. The law has to be certain. This honourable court, unless you could have pointed to another reason why this honourable court can depart from the legal point which has been stated by your brother judges in those cases, then there could be something else. This law must be certain, and the law must be certain. We cannot have, unless any other good reason, compelling legal reason has been given.
No, his argument, if you understood it, was simply that, yes, Malumo and Pinero say what they say, but there is more recent jurisprudence from South Africa indicating that you can bring this application during the trial, the 319, or kind of opening the door for that to be done. And that's why I canvassed with him to the extent of my understanding of after quickly reading through some of the cases there, that it seemed in relation it seemed to be related more to 319 subsection 2, which is the quashing of indictments.
Yes, my lord, that's what he said, but if you look at State versus Person, it's a 2003 judgment. And the Malumo judgment is a 2013 judgment, 10 years after the Person judgment. So there's no way Person judgment can be more recent than the Malumo judgment. Because it was made a decade down, the Malumo judgment was written well aware of what had been said in Person.
What is the date of the Supreme Court?
The case number is Constitutional Court 30 of 2003.
Sorry. 2003, yes.
Yes.
And
also,
Malumo was when?
Malumo was 2013.
20?
2013, my lord. Let me just be...
Which means it was after...
Yes, it was well after.
It was after even Beckwood.
Yes, my lord.
But obviously, there's nothing wrong in him seeking that I be persuaded by those authorities, isn't it? There's essentially nothing wrong with that submission. Apart from the question whether I will be so persuaded.
My lord, that submission is also wrong because I'll refer also to the matter which is not before this honorable court of matter of the Supreme Court judgment in Schroeder and another versus Solomon and 48 others, 2011, volume 1, Namibia Law Reports, 20 Supreme Court judgment.
Page 20.
Yes, 20. And at page 29.
They said the name of the case again?
is, I'll spell it for the court, SCH.
No, don't worry. It's just to say that it doesn't matter.
Schroeder.
If you have the correct citation.
Schroeder and another versus Solomon and 48 others.
Yes.
2011, volume 1 NR, page 20, and at page 29. The Supreme Court said, the ordinary rule is that a court is bound by its own decisions. And unless a decision has been arrived at some manifest oversight or misunderstanding that it is there and has been something in the nature of a palpable mistake or intention was not drawn in the previous decisions of relevant authorities. So this Honorable Court...
You were talking of which court there?
Yes.
Which court were they talking about?
This is the judgment which was made by the Supreme Court.
Talking about which court?
This is in effect any other court, my lord. It says it's ordinary.
No, I want to know from that case, was it talking about this? Because it's a different matter for a Supreme Court.
Yes.
A Supreme Court can't just depart from its decision for no substantial reasons, isn't it? A Supreme Court, because it's the highest court.
Yes.
Whereas the High Court, judges in the High Court can differ. And then the Supreme Court will finally decide the issue. So I'm simply saying, I don't think, just looking at it without having read it, that they were talking about every other court, including the magistrates' court, that what one magistrate decides necessarily must be, it is persuasive to a colleague, but not necessarily binding. I think that has always been the law. But for the Supreme Court to depart from its previous decision, it's a momentous issue.
Yes, my lord. My lord, there's a principle of stare decisis, which also comes into play in this matter, my lord. And also the High Court itself. There must have been some indication as to why the High Court can depart, and something must be brought to the attention of the High Court that these authorities were not brought to attention, was not brought to the attention of that court which made the decision before it can be persuaded to abandon a decision or the law which has been made. The High Court is known that it makes decisions which are binding, which creates law, just like the Supreme Court. So, my lord, we can't just say just lightly without any reference to any law which was not brought to the attention of the High Court judge who made that decision, or any other facts which might be a mistake which was made in deciding that matter, that the court can lightly just abandon because of that will put the administration of justice into jeopardy, my lord. Because there will be no certainty. I'm sure. Any judge can just come up with a judgment.
No, it doesn't work like that, Mr. Marondis. If any judge must depart from a colleague's judgment, he must justify his decision.
Exactly.
And the ultimate crucible for that is the Supreme Court. Then they will decide whether this other judgment was the correct approach, or in fact, the judges can even refer the question to the Supreme Court. Yeah. So let's not overemphasize the fact.
Yes,
I don't think that the case you have referred to, the Schroeder case, they were talking about every other court. I think they must have been talking about the Supreme Court departing from its own decisions.
Yes, my lord. That's correct, my lord.
Yes.
My lord, the applicant has gone on to say that...
Just one last point. You said it should have been submitted that these authorities were not brought to the court's attention. Does a reading of Malumo and the Pinero show that any of the cases like Basson were brought to their attention? I think in Marumo there's some mention of Basson and Adams or something like that.
My lord, those my perusal of the Malumo judgment, the judgment of Magidela, which he was also referring to, was mentioned, was referred to by the court in that case.
Adams.
And the judgment of Ngema was referred to, and the judgment of Pinero was referred to, and
but nothing on Person.
yes, Person was referred to, my lord, because but Person was actually honestly on a different. It's distinguishable from the facts of what was happening in Malumo, and Malumo is at all fours with what is happening in this matter.
Yes, Carol.
Yes, my lord, there's been criticism that the affidavit of the state, the answering affidavit of the state by Mr. Lutubeze is very short and scanty. But my lord, that was born out of the position that Mr. Lutubeze is so much knowledgeable about the law, my lord, that he doesn't want to burden this court with unnecessary information when the point of law is very clear in this jurisdiction. My lord, I would refer this honorable matter to this court to the matter of State versus Mike Nghipunya by your honorable judges Liebenberg and Klassen in the bail appeal. It's High Court MDs. It's the neutral association, my lord. It's Nghipunya versus the state HCD.
Sorry, HCD.
HCMD CRI.
You have changed twice now. You started with HC, now you say HCD. Which one is it?
All right, HSC stroke MD hyphen CRI hyphen appeal AP P hyphen CAL 2020 00 stroke 00077, which was handed down on the 20th of October 2020.
Mm-hmm.
The High Court said that was complaining about lengthy notice of appeal, which were brought before the court, which is so much information, some of which was repetitive and some of which was not relevant to the court. It referred to the matter of state of Vempon 275 PTY and another versus Cleveland Projects PTY Limited and another. And this is in paragraph 20 of the judgment, my lord.
What's the reference there?
The court.
What is the reference of that case?
For that case, my lord, let me just check on the footnote. It's 2014 stroke 14286. That was the case number in the civil matter, my lord. The court quoted to the following paragraph that the idea that more is better and that it is wiser to put everything before the judge belongs to the lazy and insecure. It ignores the sentiment expressed in the Pambili.
No, I don't think you need to go that far. I mean, prolixity we know is not necessary. All you are saying is, all you are saying or wanting to put to me is that you are your submissions were sufficient for the purpose.
Yes, my Lord. I wanted to emphasize.
It doesn't matter. People can use all sorts of languages. They can say it's so short and so on, but it just depends on what its content is.
Yes. But the content, my Lord, in paragraph 5 of the answering affidavit was clear, my Lord.
Can I just understand that in paragraph 5 or whatever, in your answering affidavit, your main point is, look, this is premature. An application of this nature is brought after the trial has been completed. Is that the point you are making there?
Yes, my Lord. That is what the law says in this country, my Lord.
Yeah, which other countries? Oh, we are here in this country.
Yes.
There's always an emphasis about this country. We are in this country. Yeah. So all I'm simply saying is that your point, that dismiss this application, this request or application for reservation of points of law because they must be brought at the end of the trial.
That is one point, my Lord.
Yes. The next
5.
one is.
The next one is that if you look at the
Just a minute. Right. Are the other thing the alternative or what?
The other one is that if you look at line number 8 from the bottom of page 3, of the answering affidavit.
Yeah, anyway, that one. Is it line 8?
Yes, from the bottom.
Yeah, carry on anyway. I'll look for it.
Yes, we are pointing that if they were not satisfied with the refusal of this honorary court to grant any order, they were supposed to appeal. This is based, if you look at the points of law which were raised.
You said if dissatisfied by what?
By any ruling or refusal of any to do anything by this honorable court, which follows an application by themselves, whether in written form or verbal, they should have appealed or taken any other manner other than filing a Section 319 application to address that situation. If you look at the question on question number 1, my Lord. After the introduction there's a question there. Can such a judge refuse to exercise judicial authority and interim other judicial authority ad interim other than case managing matter? It means there was a refusal by the court, according to him. He should have known when that refusal was given. And if there was a refusal, if the court has refused to do something, you appeal against that refusal, or you take an approval application. You go to question number 2.
No. You see, that is That is another point which arises in a 319 application. Whether, as a matter of fact, is that what happened? Are you able to, because there is the issue of facts, isn't it?
Yes.
Because the 319 is predicated on the understanding that the facts are clear. I used undisputed, but he didn't want that. But the facts are clear, and the court is just called upon to decide the issue of law, isn't it?
That's correct, my lord. And if you look at it, my lord, from what happened in court, the court did not refuse to do what is alleged by the applicant. The court simply says, can we wait until the outcome of the application for recusal, then we will deal with the issues. Then on the issue of refusing to hear the application for 319, the court also did not refuse to hear the application for 319. The court simply says, we defer it until the end of the plea taking. Then we handle the matter. There was no refusal by the court. But here in this case, they are giving it as if there was a refusal. But what we are saying, my lord, is that once you...
Yeah, but to be fair to them, they used refusal, or what else? They used at least 3 words.
Refusal?
They don't just say refusal, they say... What do they say?
My lord, if you look at question number 2, it says defer, hold in abeyance, or refuse to consider.
Yeah, so this is what I'm saying.
Yes,
They
or refuse to
be
consider.
Fair to them,
but
they are saying hold in abeyance, refuse, or the third one. So it's not just, they are not simply talking about refusal.
But now if you put the other way, that there was a refusal, my lord, because to them, there was a refusal. If there was a refusal by the court, then this issue of abeyance and whatever are automatically cancelled because they say there's a refusal. My lord.
In fact, I don't know the proceedings here, but in the jurisdictions where I've served or I serve, sometimes if a ruling is made and you would want to take it up, you first have to ask the judge to give reasons for that ruling, isn't it?
That's correct, my lord.
So that the higher court will then be able to know why you made that ruling.
That's correct, my lord.
It doesn't seem that is the practice here, is it?
No, it is the practice here, my lord, because for you to appeal against the order of the High Court in a criminal matter, you have to apply for leave to appeal. And for leave to appeal, there must be reasons given for the refusal of that order you seek to appeal against. And there are other considerations as well, my lord, whether that refusal was, did it dispose of the matter, or did it dispose of the right of the person who seeks to appeal. If it does not, then it's not appealable. But if it does, it is appealable. My lord, like even this on question number 3, where they raise the for legal representation. If this matter was to proceed with them without them having legal representation, something for they would have asked this honorable court to give its reasons for refusal to do so. But the court, in its judgment for recusal, it dealt at length why it made that decision to proceed with the matter in the way it did. Because the court gave a lot of the background of the history of this matter, the meetings which were made by the defense counsel and the state, and what was put before the court, and which made the court make the decision that the matter was supposed to proceed. And therefore, these facts, as the court has been asking the applicant, were available to the Supreme Court. And like this issue of legal representation, it was one of the main conditions in the application for recusal.
That's question number what?
Question number 3.
Your submission is it was covered in the recusal application.
It was covered in the recusal application. And it was the main basis of the application for recusal that this honorable court is, there were words which were used that it was bent to proceed with the trial without the accused persons being represented, in that this court did not want to respect their rights in terms of Article 12 of the Constitution. And that was the main argument in the application for recusal. But the Supreme Court has since dismissed that application for the petition, dismissed the petition for recusal. Besides that, this point was constituted of 90% of the application and the submissions which were made, my Lord. So therefore, either way, this point will not take this application further, because the Supreme Court has dealt with this and is aware of the reason which was given by this honorable court. But the point, my Lord, is that whatever it is, my Lord, these kind of questions do not require them to bring the Section 319 application, because it's based on their understanding there was a refusal of certain actions by this honorable court. Such refusal, my Lord, they should have asked for reasons, then apply for leave to appeal, and appeal against those reasons, my Lord, not to bring the Section 319 application, my Lord. My Lord, the issue of the appointment of this honorable court was also part of the recusal application. Yes, it was. And also it was raised by the applicant in one of his addresses to this honorable court, and the state replied to his application by referring him to Section 7, and this honorable court even asked the state whether it was just Section 7 or just enough. Then the state told replied that if he felt that Section 7 does not answer his queries, he was supposed to bring a substantive application which cites the appointing authority, this honorable court, and the state, and bring a substantive application challenging the application of this honorable court, which has not been done. It's not done through Section 319, my Lord, because in any event, Section 319 deals with events which happens at the trial. That's why it is supposed to be brought at the end of the trial, because it covers things which happen during the course of the trial. This is something which is not attached to this trial. It's something has to do with the appointment of this honorable court, which has nothing to do with the proceedings before this honorable court, my Lord. So you are supposed to bring a substantive application, not 319, as he's supposed to do, my Lord. So, my Lord, in short, this was the wrong procedure which was followed, and the state insists that this application, as was said in the matter of Status versus Malumu, which is in the Ndala case, is misplaced and is meant to delay the continuation of this trial. There's been some denial or some claiming that they are not delaying the trial of this matter, but it is indeed the state which is delaying the continuation of this trial. The state, my Lord, ever since the plea-taking commenced, has ever been continuing to continue with the process, my Lord, and has never asked that this proceedings stop, my Lord. The reference which is made to the disclosure of 40 volumes, that it is the state delaying, that is something which happened not after the commencement of the plea-taking. It was because the accused himself requested, because he was aware that the ACC had previously, in the other years, investigated corruption at the Ministry of Fisheries. And those cases had been closed because the ACC could not make headway of it. And he requested the dockets which had been previously worked on by the ACC, which have nothing to do with this trial, my lord. The state disclosed those dockets to him, and the state had never wanted to rely on those dockets for the purpose of this trial. So those dockets which were given to him on this, which says 40 volumes, were at the instance of the accused persons who wanted to see previous investigations by the ACC into the corruption at fisheries, but not this matter, my lord. So those dockets, the state had never wanted to rely on them, and the state had not seen those dockets, but it requested from the Anti-Corruption Commission to provide those dockets. They were provided, and they were disclosed to the accused person.
But what point is he concerned with or about in relation to the production disclosure in February? What is his point?
His point is that the state is delaying because it did not disclose other information which was it having in its possession concerning this matter. But the point of the state is that disclosure is not part of this docket, of this matter, of this particular trial matter. It's dockets relating to previous investigations into corruption at the Ministry of Fisheries.
Question number 4, which you didn't directly deal with, he raises that issue. In what context? He raises the issue of those volumes, isn't it?
Yes, my lord.
In what context? I don't want to explain to you, but in my understanding, he's saying that the state disclosed this in time and given them sufficient time to study them. That could well have affected the plea that they were going to tender.
My lord, the state disclosed the docket during the year 2021, my lord. After the court state had been ordered by the court, when the matter first appeared in this court on the 21st of April 2021. And the state disclosed the docket, which was at its position. And the state disclosed all the evidence which it was going to rely upon in the trial. And the pre-trial conference, which was to be relied by the accused persons, none of them chose to reply that pre-trial conference memorandum, and none of them sought anything from the state that they want any additional information. This information was only requested in December 2023, my lord, when this matter was already due for trial, my lord. After it was that request was made, the state then disclosed that additional information, which was only requested when this trial proceedings had commenced. So it is not correct, as is alleged in question number 4, my lord, that this disclosure was just made. It was as a result of the request. If they'd requested that request, my lord, in April 2021, before this matter had commenced, that disclosure would have been made as was done by the state promptly upon request to do so. So
you are saying all the documents disclosed on 15 February are irrelevant to this trial?
The state never said it's going to rely on those documents, but because the accused persons requested them, we gave them those documents because maybe they might get something from there. We will hear when we go on with the trial. But
the position of the state is that they are irrelevant.
As far as the state is concerned, they have no relevance to this honorable court. But they might find something relevant to them. We don't know. But the state is not going to rely on those documents, my lord.
So that disclosure was in terms of what?
It was a request made by the accused person that they wanted to see those documents. And it was not an order of the court that it should be.
In terms of what? Because, you see, the informality which seems to pervade some of these proceedings make it very difficult to handle some of the matters. And that's why when I ask the question, that disclosure of 15 February, was made in terms of what? Was it just, Mr. Marondeze, can I have those matters? And then you say, okay, yeah, the 30 volumes. Is that how it was handled?
No, they filed a document before this honorable court, which is termed status hearing. That is where that request was made, my lord.
And you responded positively?
And we disclosed that, my lord, without being ordered by the court to do so. We responded to that document, my lord.
Even though you thought they were irrelevant?
Yes, but the accused persons are entitled to request any information which they might feel that will be useful to them during the trial, my lord.
That I understand.
Which is in possession of the state.
Entitled to give that information, isn't it?
Yes.
Even if it is irrelevant.
Yes, we gave them, my lord, because they wanted it.
All right.
Even if they request anything else, my lord, which the state is, we will give them.
But their point is the non-disclosure or the disclosure on 15 February 2024. Of course, it's speculative, but they are saying that disclosure could have given reason for them to approach their pleas in a different manner.
My lord, that's why I gave the background of the matter, my lord. If they cooperated with the state from the time when the state filed the pre-trial conference and they filed their pre-conference and requested any other documents in 2021 and 2022, well before 2023 when this matter started, that would have been given, my lord. But they sat down and did not do anything about it.
No, just for the record, is it correct that none of the party or all the accused persons refused or declined to deal with the pre-trial, the state's pre-trial memorandum? Just for the record.
That's on record, my lord. They said they will not respond to the pre-trial conference of the state. Initially, in 2021, after the pre-trial conference memorandum was filed, counsel for accused number counsel for accused number accused number 7, 8, and 9 filed a request for further particulars, which was provided. The further particulars were provided, and they went mute. And later on, when they appeared before this court, they indicated that they will not respond to the pre-trial conference.
Pre-trial memorandum.
Pre-trial memorandum, my lord. Sorry, my lord.
No, just for information, right?
Yes.
Okay. Yeah.
So, my lord, it would be a misnomer to say that the state did not want to disclose any information, because the state disclosed the information which it was going to rely on, which was in its possession. That docket was never given to the state by the SEC. We only came to know about it when it was requested through that document written in status hearing, my lord, and we requested from the SEC to bring the documents which were disclosed, my lord. So, in any event, my lord, I don't see how it would have affected them. If they knew that and they wanted to cooperate, they would have requested in time. And in any event, all of them have indicated the court that they are pleading not guilty to the charges, and they are not given the particulars of how and on what basis they are basing of their defense, my lord. So they've been having these documents since February, and if they want to...
So can you just summarize your
my lord,
your opposition to me, the basis of the opposition?
The opposition, my lord, the opposition is that the final point is that the opposition, to emphasize, my lord, is that the procedure which has been followed is wrong.
The procedure followed, you mean which one?
Pardon, my lord.
By procedure followed, which is wrong, we mean which one?
The procedure of bringing the 319, at the timing of bringing the 319 application is wrong. It should be brought at the end of the trial.
I thought those were two distinct issues.
And
the one argument or the one contention by yourself, I want to be clear, is that this application is premature.
Yes.
It must come at the end of the trial.
Yes.
Right. And the procedural side, is that what you call the procedural objection?
Yes, my lord. That's what I'm saying, that it's premature. A procedure that is premature, my lord. And the second part is that from the couching of the so-called points of law, my lord, they should have exercised their rights to appeal against what they call refusals by this honorable court.
Yes.
And that's the issue of that the state has delayed is delayed the commencement of this trial and the continuation of this trial is not correct.
No, your submission, your position, not theirs.
Yes, my lord. That's a submission of the state, my lord.
No,
that is not correct.
No. What I'm saying, what is your position? Do you maintain that this application was brought in order to cause delay?
Yes, my lord. The state submission that is that the state.
No, my question is, do you still hold the position that this application is intended to cause delay?
Indeed so, my lord.
Which, of course, they've dealt with to show that actually, no, it is not intended to achieve that end.
It is, my lord, because all these points are without merit, my lord. And as indicated in paragraph 5 of our answering affidavit, this application will only result in the further delay of the trial. Because today, if this application is not gone on, we would have continued with the trial, my lord. Those are the submissions of the state. Unless the court wishes the state to answer any other particular question.
Yeah, I'm not going to ask you to do that, but I observed that you didn't want to deal with directly with two issues I raised with Mr. Shanghala, which is the factual basis of these questions, whether the facts are clear, and the second one being, what's the second one? The second one being whether which of these questions have been addressed in the recusal application.
My lord, if you look at the founding affidavit does not give any narrations of any factual or of any facts. What it simply does is to list the questions of the so-called questions of law. So there are no facts at all which were given in the founding affidavit.
What were they supposed to give?
What you are supposed to do was supposed to narrate in this affidavit the events as they unfolded in this honorable court and what transpired in this honorable court, which led to him to come to those conclusions, which he terms of facts of questions of law. And also, my Lord, the second question, questions 3, 5, and 7 were extensively dealt with in the judgment.
Which one? The recusal judgment.
Yes, my Lord.
All right, I want you to answer this question if you can. Am I correct to perceive that the question in relation to the judge's appointment, that is 5, 6, and 7, right, or one or other of those?
Yes, is question 5, 6. Yes.
If I were to reserve those questions for the Supreme Court, would it not have to hear evidence to establish facts? Or do you agree with him that, well, it speaks for itself or something like that? I'm simply saying, because he didn't bring an application like you postulated, isn't it?
Yes.
In which case, of course, the appointing authorities would have defended their position and so on.
Yes, but
he proceeded on the basis that, look, as a matter of fact, the appointment lapsed end of December, right?
Yes, that's
now,
what.
My question is, if you make a reference of that question to the Supreme Court, would they not have to be satisfied on certain facts? And if they have to be satisfied on certain facts, what are those facts? Or is it purely just a question of law?
It's not a question of law, my Lord. Because if the Supreme Court will have to decide this matter, his main obstacle is that there's Section 7 of the High Court Act, which says that when a matter is commenced, the judge becomes seized with the matter and does not need to be reappointed, the acting judge, until you finalize that matter. Now, in his questions, he has not given any facts as to why he believes that this matter falls outside the ambit of Section 7, and
but he has argued that the matter is not commenced.
Why is he saying that it is not commenced, my Lord? Because we all know how, everyone knows how the matter, how a criminal trial commences. It commences by taking...
What does he say? What does he say in respect of commencement? What does he say, if you understood him? When does he say the trial commences?
No, I think it's based on the misconception that only when evidence has been adduced is when the trial starts. That's what he says in paragraph 3.6. That's his understanding, but that's a clearly, the Supreme Court can never consider that unless he has given other.
So when does the trial start, commence?
The trial starts by taking of pleas, and they said yes, the matter is starting, can the charges be put to the accused persons, and we put the charges, then thereafter when evidence is laid, my Lord. Trial commences when charges are put to the accused persons and their pleas are taken down, my Lord.
Okay. Anything else?
Nothing further, my Lord.
Mr. Shanghala.
Judge, I would like to introduce a word into the lexicon of this trial. I will spell it. K-U-N-Y-E-P-A. In Shona kunyepa, it means to lie. This is what we've been hearing. And I want to read, now I'll read it, because last time I should have read it actually. I will read to you what Justice Moses Chinhengo said in Botswana. In the case of State versus Lunyanga, 2008, 2 BLR 524, he said this. It must be said, I think that prosecutors should be individuals of integrity. Their conduct should be honest and sincere, and they should respect, protect, and uphold justice, human dignity, and fundamental rights as entrenched in the Constitution. They must strive to be consistent, independent, and impartial. It is their duty to act without fear or favor. In paragraph 26 of the replying affidavit, I said, what Chinhengo J said in Botswana applies, in my humble view, to Namibian prosecutors, if not all prosecutors the world over. Any conduct falling less than that should be reported to the Law Society of Namibia for those prosecutors who are members of the Law Society of Namibia or aspirant legal practitioners. And the rest who are public servants, please, they must be reported to the Public Service Commission. Kunyepa, in my language, is only lies. Let me point them out. First of all, Schroeder, the case that he refers to, deals with Section 17 of the Supreme Court Act, that the judgments of the Supreme Court Act are binding, or the Supreme Court are binding. In Article 81 of the Constitution, it has no bearing here. Here the issue is whether or not this court is bound by horizontal jurisprudence, by the judgment of another court. With respect, I say no. If, for instance, the argument was, Maluma was a full bench of the High Court, this court would ought to say, I need to consider this because it is possible that this bench of weight considered...
I thought he considered when I canvassed the issue with him.
Excuse me, Judge?
I thought he considered when I canvassed the issue with him.
In the abundance of caution, I want to put it on record. Yeah. Malumo, he says, is on all fours of this case. Not so. I tried to explain that in Malumo, a Section 106, sub 1, paragraph F plea was tendered. Was one tendered here? The astounding response is no. And then when that failed, counsel then sought to reserve questions. And then the court found, basically, that that was an abusive process. It is not on all fours here. I've distinguished Pinheiro. Judge Tradham himself says so in Pinheiro, that they dealt with the issue of the confiscation of those assets under the Sea Fisheries Act.
The significance to me of those two cases is just the statement that this application must be brought after. If that statement is there as the basis for the decision of the court, then that is the position in those cases.
Yes, but it is not the proposition to say, therefore, that you shouldn't consider Basson, because what I'm giving you is this.
No, Mr. Shanghala, we don't have to go back.
I feel I do.
No. You have made your submissions on Basson, isn't it? And other cases which seem to which are some jurisprudence to the effect that you don't have to be confined to the ratio or ratios in Malumo, Pinero. You can go wider, isn't it? That's basically your submission, isn't it?
Yes, it is. And
is it more than that?
And if you will recall, Judge, I was trying to say that the Basson judgment, I beseech the court to consider it because it is more pro the rights of an accused. Because if it allows the determination of that question of law for me to revert to pretrial, I may then be in a position to assert my rights, something which I'm prevented by how the court conducted itself into me getting into the plea stage. Quickly out of that, with the pending questions that I've submitted before court before it started with the plea. Pending still today. That is the issue. So I gave you the Latin expression, in dubis praeferenda benigniora sunt.
In reply, Mr. Shanghala, you need to deal with new points raised by.
I'm following them right now here. I'm following. I thought what I had taken down what he was saying, but let me start where he made a concession. He says it's neither here nor there if it's an ex parte application. It's in the criminal trial. I don't know why he's even raising that. This case number is this criminal trial's case number. We never said we went out to, a motion court. We came here, and that's what I said, that Section 319 doesn't give you the how. It just says you may. And that is why I'm here with this how, having utilized an ex parte, because I'm not looking for any relief against anybody. But he says, he concedes it's neither here nor there. It's before the criminal court. So that point is moot. But Judge, I'd like you to not consider the other things he said, such as the issues relating to the lengthy notice of appeal. First of all, my notice of appeal, my notice of motion is not lengthy. It contains the questions, period. What he was relating to was a bail question, a question when the notice of appeal had lots of questions, and then the main issues were only 3. And then the court admonished and said, don't come with 17 questions where you only have 3 questions. That was the issue in that case. Again, Kunyepa. Then he says the signature is his. Fine and well. He's tendering evidence now. Why didn't he put that in the affidavit? If it is him and he's a prosecutor, I don't doubt he's a prosecutor, he still doesn't answer the second question. Does him being a prosecutor automatically mean everything comes before his way as a prosecutor in that office he can deal with? Is that the case? How do we know? He doesn't say so. The only case I know that deals with prosecutorial authority is the case of Vemburuka. When yours truly brought in these people to act as a PG, and while we were waiting for this current boss of theirs to be admitted under provision we made for her, and then we are challenged about whether that can be an acting prosecutor general. Stravinsky, the one I opened here, the one he's talking about, I couldn't find. That one is talking about other things. Kunyepa. Then I go to his signature. If it's his signature, let's accept the evidence he tenders, which he didn't tender it, he sends and falls by his papers. But if the judge were to erroneously consider that information, then why doesn't he say, Maron Deze, Deputy Prosecutor General, because I'm duly authorized? He says PPPG. Why does he PP the PG? Did she tell you you can PP, you can sign this one? Where's that per procurationem authority? Then, apparently I should have appealed. Judge, because I think I said it maybe better than I can ever say it again. In the replying affidavit, at paragraphs want to give them to you. Paragraphs 68 to 72, that's paragraph 81 of the heads of argument. I say...
Paragraph?
Yes?
You said 60?
It's 68 to 72 in the replying affidavit, but it is paragraph 81 in the heads of argument. That's on page 17 of the heads of argument. I say, in the case of Shetu Trading, O'Regan, acting judge at paragraph 19, refers to, with approval, to the case of Zweni. I was reading this and you stopped me, but now I want to read it in, please. As well as Dickinson and another versus Fisher's Executors 1914 on the distinction between judgments and orders which are appealable and rulings which are not. The Criminal Procedure Act of 1977, the Supreme Court Act of 1990, and the High Court Act of 1990 all refer to judgments and orders, not rulings. In the case of Disavino versus Nedbank Namibia Limited, Chief Justice Shivute quoted with approval the case of Pretoria Garrison Institutes versus Danish Variety Products Limited, 1948, wherein at 869, Schreiner, Judge of Appeal, referred to the case of Globe and Phoenix GM Company versus Rhodesian Corporation, 1932, Appellate Division, and the judgments of Vessels and Kerr-Lewis therein that the principle emerges that a preparatory or procedural order is a simple interlocutory order and therefore not appealable unless it is such as to dispose of any issue or any portion of the issue in the main action or suit.
Appealable as of right, isn't it?
Yes, which amounts, I think, to the same thing unless it irreparably anticipates or precludes some of the relief which would or might be given at the hearing. But I also refer to Eliphas and others versus Asino and others in 2020 in the Supreme Court.
But all those cases make the, Mr. Shanghala,
Yes?
all those cases make the same point, isn't it?
Yes, that an order giving a direction.
And I had the occasion to deal with the Shetu and all those in one of my judgments in 2021.
Yeah.
Yep. So I'm quite familiar with those cases.
Okay, let me move now to the other aspect.
But the point I wanted to draw your attention to
Yes,
is that these purely interlocutory rulings, isn't it,
Yes.
are not appealable as of right. Correct?
Yes, but then the point he should have made was, I should have sought leave to appeal, not that I should have appealed. He says I should have appealed. He's wrong. In other words, also, Judge, if he says I brought an irregular procedure, the rules of court have provisions for irregular procedure. He didn't. He chose to bring a scanty 3-page affidavit. He stands and falls on that one. These are the things. I'm surprised that out of 3 pages, you can make a sermon of 45 minutes. Then, Judge, he says, it's 2 different cases. That disclosure has nothing to do with this case. Judge, please, if you may, turn to page 87 of the bundle. I've referred it to you again before. Page 87 of the bundle says, case file number ACC error 0-14-001270. This is apparently the evidence. He says, we just gave it to them because they asked for it. It's not necessary. That case is closed. Well, guess what? Let's go to what they disclosed to us, what they disclosed in 2021. Again, it's written ACC ERO 14-001270. Am I missing something? These are the same numbers and letters. It's the same case. Evidence was being withheld. Again, Kunyepa. That case is not closed. It's this case. I've never seen a case which is open today for anticipatory crimes in the future. So 2014, and they've been waiting for Shanghala to be appointed as AG minister, and then they bring the case. There's a conspiracy here. And Judge, you don't have to believe me. No. Here's the book. They've disclosed their conspiracy. They want to drag out, apparently they're saying, Judge, start this case. Start this case. It should be no surprise I was arrested on election day, 27 November 2019. 27 November 2024 is election day. Here, this book says, start the case so that the case can be drawn out well into the election date, so that the electorate doesn't forget what happened to SWAPO in 2019.
What book is that?
This book here is called Fishrot, Fisheries and Corruption in Namibia, written by the good people Roman Greenberg, Shinovene Emmanuel, and Tangeni Amupavi. This is what this book says.
It says what?
I'll read it to you.
No, just
it says.
Just summarize.
It says, start the case. Drag long drawn case into the election 2024 so that the electorate may not forget what happened to SWAPO in 2019. You see, Judge, I put on your bundle of documents there, underneath, an article from The Economist magazine. It talks about the Financial Action Task Force, the very body that caused that government, this state, this country, amend the POCA last year to add the powers of the ACC, of Section 83 to the ACC. And it says that FATF has been abused, even by democracies. I'm saying somebody has taken a hold of the criminal justice system. They've weaponized it, and they're using financial crimes. So this is the 9 July, The Economist newspaper. I put it on the bundles there.
What point are you making?
The point I'm making is, Okunyepa, they are lying. They are following. This is not about law. If it was about law, Judge, they would not be telling the lies that they are telling. And the point is this. They are ready to prosecute if they are willing not to disclose the information. Because how do you explain 4 disclosures? Were all of them requested by us? Let me tell you what happens. When somebody goes to bail, they go and investigate, and then they disclose again. When somebody goes to bail, recently, one Andreas Kanyangela has been seen lurking around the Ministry of Fisheries, asking people to change their statements. If it is not true, then why, after Mr. Ricardo Gustavo was testifying, and they hadn't disclosed it before, then after November 2021, 7 months after the April 2021 disclosure, they bring a new disclosure. Then they disclose to us. They disclose meetings from NAMSOV, Rabi, and all those things. And they are on the witness list. If they are not necessary and the case is closed, why are they being disclosed now? Why are they put on the witness list? It's not true, Okunyepa again, Ori. These people are abusing. This institution is not acting as if it's an institution that is bound by Article 5 of the Constitution. So what I'm saying to you, judges, why should you believe them when I've shown you how they have lied? The affidavits are here. We don't need the Marine de Klerk here. They go and make affidavits. No, they have been removed. We don't need the Scandinavians. They are looking for them to be brought into this case. Same case number.
But you know that in making my determination, isn't it? You know that in making my determination, I will consider, throw out whatever frills there are.
Yeah.
So it doesn't matter how far or how expansive one becomes, whether it is the state or yourselves. I will have to make a decision based on what I consider to be the relevant submissions to this issue.
Judge,
so don't concern yourself too much with whether they are lying and so on. You can only indicate, as you have indicated earlier on,
yes,
that this is my position, their position is not tenable or it's untenable, and we take it from there.
Lastly, it's the question you asked, the facts. Judge, I'm very well aware that even in your judgment at paragraph 70, that's the judgment of the recusal. Excuse me. You say that it is alleged that you denied me, accused 3, from raising 319 questions of law. I am aware of your stance on that issue.
Mm-hmm.
I, of course, believe that you stopped me, you blocked me, you precluded me from, you denied me the opportunity to, you made it impossible for me to. Whichever word you use, an adjective to describe what happened, I couldn't, I wanted to. And the reason is it would happen only after or at some future point. The question is that fact recorded in the record? And I say it is. Regrettably, the record is not here.
But
I don't have it.
If it is in the judgment, it is on record.
Yes. But I've requested for the record. I would like to have a copy of the record. I will try again. If I fail, I will probably be forced to make an application for the record. I don't know, because you said you just want applications. Maybe from here standing you will allow me. But I say that the facts, particularly on the issue that relates to the appointment of the judge, ex facie, the government notice and the government proclamation, which is in the notice, in the government gazette, those are the facts. The state of mind of the decision maker is not the issue. In any event, Judge, when questions of law are entertained by the Supreme Court, I'm not going to be there alone. The ex parte is here. When it is determined there, the court may make directions. The Supreme Court may make directions. So the state will be given an opportunity to file whatever arguments, and they are free, if evidence would be allowed, to go and get an affidavit from the Secretary of the Judicial Service Commission, the Judge President.
Well, the point I was making with Shanghala about in terms of 315, my understanding, if I'm wrong, I'm wrong. But my understanding is that the court is not supposed to be, the Supreme Court is not supposed to be preoccupied with establishing facts. That's why it says your question of law must be based on clear facts, so that they are not contested. The facts are clear. Then you say the question of law is the following. And the Supreme Court doesn't have to go outside to establish facts like a court of first instance.
I agree with you.
Yes. So that is the extent to which the clarity of facts is required, so that the Supreme Court doesn't have to be concerned with those.
I fully agree with the court. I just have a different interpretation of what happened. The court has a different interpretation. Court is of the view that factually didn't happen, that...
No, don't conclude for me. I will make my conclusion later.
Okay, Judge. My apologies.
My views here, my questions here are intended to clarify things. That's not my decision. You'll get my decision in due course.
Wonderful. Judge, on that note, I have exhausted my issues. I see it's 5:04. I raised issues we ought to discuss, but I stand to be guided, Judge. Maybe, perhaps, we could interact with the prosecution and the other parties, the other accused persons, and prepare some type of a report to the court on those issues that I wanted to discuss, so that we don't detain the court here any further.
You go back to the question whether, if my appointment is invalid, whether I can deal with anything. You see, just like with the recusal. If it is invalid, or if I think in the court of appeal, why do you engage somebody to do something which doesn't work? You carry on with work, you find that your appointment was invalid from the 1st of January 2024. All your decisions are made by an inappropriately appointed judge. That's the end of the story.
Well, for what it's worth, Judge, I'm still the same person who said that I believe that until a determination is made, a judge is vested with his office and must be able to execute the functions of office fully, unless there's a specific issue.
But that's the question you want to refer to the Supreme Court, isn't it?
Because I believe that it's an important question of law, and that it may have a bearing in the future determination of this matter. Thank you, Judge.
Yes. And now I'll proceed to do the only task which you you agree I can do, which is to reserve my judgment to the 8th, is it? I'm asking the date. Is it 8? That's the 8th August. Yeah. And the usual order is made in relation to the continued custody of the accused accused persons, including the applicants, except for the accused person who is on bail.
Yes, the court, please, my lord.
As the court, please.
As the court, please.
Yes.
My Lord, just to confirm the date, 8 August 2024 at 10 o'clock for the ruling. As the court pleases.
That is the anticipated date. It can be
So
sooner.
noted.
It can be sooner. And if it is sooner, depending on the outcome, other things can happen. Right. The court adjourns.